Good morning, everyone. We are starting a little early. We have at 9 o'clock some bond hearings involving Mr. Reed. So if any of you are on the call for cases other than Mr. Reed, those other calendars don't start till 9:30. You can be at ease. Mr. Reed's lawyer should be Mr. Jerome. I don't see him on our roster of participants. So if you're not Mr. Jerome, be at ease. And at 9:30, we'll pivot to, we've got an inquiry calendar, plea and arraignment calendar, and an add-on. We'll figure out what we're doing with all those. Our next door neighbor is presiding, and today she's got the presiding bond calendar, and that just means there's a lot of congestion in the lockup area. So we may be a little delayed in getting certain defendants into court because we're sharing some space today. Other than that, we should be good to go. Hopefully one of our deputies will materialize soon.
I spoke to yesterday.
You're going to be in person? Okay. Is the door locked out there or? Okay.
You're not coming back to me.
Brenda, do we have a moment?
You may have a moment. Oh my goodness, look who's here.
No.
And she voted.
Yeah. It was prior to the.
Yeah. 20-point loss. Ouch. What? It was that bad? It's time to just lie down with the little guy.
It was 18-1.
Yeah.
Like 5 minutes left, something like that.
Yeah.
We have everybody but Hill.
Okay. Yeah. I'm sorry I was on the phone. There. I don't know that there was.
No, I have, because they still got 19, so.
They're presiding, and so they've got the, because I was all set to go over and like, you did this again, and I remembered, wait, she's presiding today. So so as long as we've got Mr. Reed up, that's the first thing we'll do, and then 9:30 we hit the other things, and we'll just.
It's gonna be a long day. Might be a long.
Hopefully we have some pleas.
Probably. Yeah, because I had 2 of them trying to order the CEO.
What's up, Sarge?
What's going on?
Did you watch that Heat game? I was gonna say what game? Because it wasn't a game. It was like a ritual slaughter.
And they didn't even have Marcus Smart.
I know. It's like they had no defense. And yet, but you know, it's just all a setup to lose to the Warriors. It sort of doesn't matter.
Yeah, that's what I don't see nobody beating the Warriors.
Yeah. It's coming out. Yeah.
Breaking the feet up, or you know?
Yeah, I'm gonna bring them up later.
I'll later.
We can, if it's helpful to do them first, we can do that. I'm happy to accommodate because of the congestion we have with our neighbors. If it makes sense to do them first or last, just let me know so that I can let the lawyers know. There may be some folks who say, great, I'll be back in an hour kind of thing.
I didn't bring any females.
Okay, so we don't have them. Let me figure out who they are.
There are 2 of them are CEOs that we've been trying to get forever.
Excellent. I'm glad they're here.
Take care. Okay. You survived after yesterday? I did.
So we have 3 females in here, they're still down in detention.
Okay. I'm looking for 3 females.
They're on,
Sandra LaSalle? She says she's on bond. Oh, I got this whole other calendar here. No, I don't have a calendar here. Tiffany Singer?
yeah. She's produced.
Catherine Sanders or something.
Cassandra Reed,
Oh, Tiala Hall
yes.
or Tila Hall? Okay. And then Cassandra Reed? Okay. So those 3 are downstairs and Mr. Hill, basically the first 4 on the plea and arraignment. Okay. What we're gonna do with Mr. Wright's cases. We're, you need her for how long do you need her?
Well, hold on, wait.
What's he up to?
He tried bullying me.
Catering for him.
Oh,
So he's trying.
he needs to talk shop.
Yeah. Trying to wear it. Wow. So this is a status calendar, you know. So you said the afternoon.
Yes, I know. We're gonna set a tone. Uh-oh, why'd we get the white shirt in here?
Morning, sir.
Good morning. Everyone is doing a great job, except for Gordon. He didn't sleep well because the heat lost so badly.
Well, you better get used to it.
That's what I'm saying.
Who's your pick, Your Honor?
I'm from Oakland. Golden State, all the way. They're gonna do it without KD this year. They don't need KD.
It doesn't look like it.
No, doesn't look like it.
They're better off without.
Less drama.
Yeah.
He can stay in Brooklyn.
I tell you, Boston looks good, though.
Yeah.
They do. Oh, it's 2-2. I mean, the 2 games where they didn't look as good, but it's interesting. He'll go back to Miami soon. We'll see what happens.
He in 6.
Heat in 6.
They're gonna have to do a little more than they've been doing these last 2 games.
Yep.
Definitely.
I haven't seen you. So it must be just a time. Look at the date.
That's what I'm doing.
Yeah, that's the regular. Yeah, that's it.
So you've been calling these names like, none of these people is here.
Some of the wrong calendar.
Oh.
You focused on this catering and you give them the wrong calendar.
Yeah, he gave me this calendar this morning.
Oh. Yeah.
I didn't even pay attention to the date.
All right, so is Mr. Jerome, what are we doing?
So, when I saw Mr. Jerome yesterday.
Look like he really is, right?
He is frazzled. He keeps waiting for Dwayne Wade to show up. I said, that's long ago. There's no more Dwayne Wade.
Yeah, but unlike the heat, he's gonna pull it together.
Yeah, he better.
No, I appreciate it, Your Honor.
Thank you, sir.
I'm going to the warm up. I'm going to tell this morning.
That's why he's on. Okay. That's position 3. Okay. Right.
You want to hear that?
Okay. Want the first offender on. The drug case would go away. Okay. So there are how many CP cases? Okay. It's what's holding him, the fact. Okay, all right. The global resolution would involve some time in custody? Okay. Got it. Okay. So he's talking with the family? All right. Yes, we do, and we need to get Mr. Reed out here. Okay. Okay, I noticed there's a case with his name on it. So does he have someone filling in for him, or?
She just sent that saying he's gonna be out.
Okay.
It's his assistant. Basically, if she responds no, then that means that that would be continued to.
Yeah.
There's a warrant.
Oh, do we have it?
Just on it.
That's, oh, I see it on there. Okay.
Something's going on here. It was a court case.
I guess I should. So I'm in Odyssey. Yeah. All right, let's bring Mr. Reed out, please.
Your Honor, I wanted to see if I could speak to my client for 1 minute.
So we were supposed to start at 9. I'm not going to let this delay everything else we've got starting at 9:30. So let's bring Mr. Reed out. We'll get on the record what we need to get on the record. If you need to chat with him afterwards, we can certainly accommodate that.
All right. That's the case if something's going on in it. All right. But we're not gonna be cleaning it up today. You said what's going on? So we're gonna discuss your case. We're not gonna be cleaning it up today. Okay.
All right, let's get on the record in Mr. Reed's matters. He has 4 cases on our bond calendar this morning. He actually has bond in at least one of those cases. And Mr. Reed then has, I believe it's 7 unindicted cases as well. Ms. Charles, so we've got Ms. Charles for the state, Mr. Jerome here in court on behalf of Mr. Reed, who's also here in court. And Mr. Jerome, I think Ms. Charles is going to get a couple things on the record. You should know she helped update me as to where you were, meaning the parties in maybe negotiating things, because I asked what we were going to do this morning. And Ms. Charles explained that there may be a global resolution in the offing, but there are a couple moving parts. One would be the unindicted cases, and maybe there's been a waiver of indictment so that they could be accused. But we also have one case, position 3, where it's a different prosecutor, Mr. Thomas. He's joined us. He's here virtually. He's joined through Zoom. But your efforts to resolve that case necessarily include him, but I think he's in the loop. Anyway, what we'll do this morning is let Ms. Charles get on the record what she wants to. We can talk about bond if we need to. It sounds like any effort to resolve everything will be delayed a little bit because of the lack of the accusations, but I'm going to let you guys get out what you want to get out. So Ms. Charles, why don't you get us started, and then I'll see what Mr. Jerome wants to do in connection with bond.
Thank you. Good morning. Your Honor, as you correctly stated, we are.
Is your microphone, I just want to make sure you're on green.
Yes, it's off.
Great.
Your Honor, as you correctly stated, we are in the process of working through a global resolution for Mr. Reed's cases to include the unindicted as well as the domestic violence case. However, before we do that, Your Honor, I do need to get on the record and make the defendant aware that Mr. Jerome, his attorney, currently has 2 pending cases in our office where Mr. Jerome is the defendant, and would need for Mr. Reed to waive on the record any potential conflicts that may arise as a result of his attorney being a defendant in 2 open cases here in the county.
Okay, thank you for flagging that. Mr. Jerome, have you had an opportunity to discuss with Mr. Reed your situation?
No, I haven't, Your Honor. I don't believe that there is a conflict here, Your Honor, that I am the defendant in the case. We are not, there is no conflict between me and the district attorney's office. I represent defendants against them. We are opposing parties in that case, and we're opposing parties in this case. So there is no conflict. The state at this point is only raising the issue to harass me. And so, Honor, there's no need for Mr. Reed to waive any conflicts because there are none.
Well, I don't know about the harassment part, but I'm going to play out a hypothetical, which is why I believe there is the appearance of a potential conflict. And Mr. Reed will need to let me know that he's all right proceeding with you as his lawyer. Here's a possibility of a conflict. Your cases, meaning where you are a possible defendant, may gather some momentum and you are interested in resolving them in a way favorable to you as the defendant in those cases. That might cause you, hypothetically, to maybe bargain less forcefully on behalf of your clients because you don't want to have assistant DAs frustrated with you being hard-nosed and doing what you're legally entitled to do, but maybe you're doing it in a way you might normally do, in an aggressive, zealous way on behalf of your client. And you might consciously or subconsciously throttle back on that a little bit because you don't want to make waves with the office where you're trying to make a deal through a lawyer for your two cases. I'm not saying that will happen. I'm not saying your cases will, where you're a defendant, will go anywhere. But I think that any client you represent, in my courtroom at least, we're going to need to have that discussion, because that defendant needs to understand that there is that potential out there that you might choose to push a little less hard for your client because you don't want to make waves on the other side of what is ultimately the other side of your case as well. Would you ever do that? You're saying no, and that's great. But your clients are entitled to know that that potential conflict is out there. I see it as a real potential conflict. And so I think Ms. Charles was correct to flag it in the discreet way she did. We're not diving into any of the circumstances, but Mr. Reed is going to need to be able to tell me that he is comfortable having you continue to represent him, even though you find yourself in a situation you're in. Okay?
Yes, Your Honor. And, I mean, to that effect, I understand that completely. The state knows that their accusations are false. They know that, essentially, this is all just essentially a witch hunt. I've already provided evidence to them. They know this. They still haven't dropped the charges. So at this point, essentially, they're just dragging this on so that they can continue to do what they're doing right now.
Could well be.
I understand where Your Honor is coming from with this, but I know that there's not going to be any plea. There's not going to be any agreement on this whatsoever.
Okay. And you may be right, and it may be that those are dismissed.
I understand what you're saying, but I just want to make it clear to the court, and I just want to make sure that it's on the record. You know what I mean? I object. There is no conflict. The state is engaging in harassing behavior. They're trying to impede my practice of law. They're trying to limit my earning potential. And so I just want to make sure that we have that on the record.
Okay, that is on the record.
Mr. Reed is aware. He is going to waive, but I just want to make sure that I put that on the record.
Got it. Thank you for doing that. So, Mr. Reed, have you followed the discussion that Mr. Jerome and I have been having?
Yes.
Do you have any concerns about Mr. Jerome continuing to represent you?
I don't believe what he has going on should affect me.
Okay. So you're not concerned about his situation affecting your situation?
That shouldn't affect my situation, should it?
I don't know. I'm not saying it is or isn't. I was talking to Mr. Jerome about why I think we need to have the conversation. Did you follow the pretend example that I came up with?
I did.
Okay. So that's the concern that someone just watching from a distance might have. It's like, wait a minute, your lawyer, he's actually a defendant in a case with the DA's office. And so maybe your lawyer won't fight quite so hard for you because he doesn't want to annoy the prosecutor, because then maybe he'd get a better deal in his case. Now, Mr. Jerome has made clear there's no deal in my case. I'm not trying to work my case out. And my case is separate from what's going on with Mr. Reed. And that's his belief, and we all need to respect that. I need to understand your belief. If you are comfortable having Mr. Jerome represent you, understanding that he's got this other thing going on, then we can keep on moving forward. If you've got concerns about it, you and Mr. Jerome need to talk about that some, and then you need to let me know, hey, I'm sticking with this guy. I get it, but that doesn't concern me. Or you may say, you know what, Judge, now that I better understand this, I think my family and I need to find a different lawyer. Your decision, not Mr. Jerome's, not Ms. Charles, not mine.
I'm fine with moving forward with the case with him. I don't believe his outcome should have anything to do with my case, though. Him being my lawyer, I understand they have a situation, but it shouldn't have anything to do with him with my outcome.
Okay. Well, here's my invitation to you. If you begin to have a concern that his situation is affecting your situation, let me know that and we'll talk about it. My sense is your situation is going to get wrapped up real soon. And so whatever his situation is going to be on down the road a little bit. But I feel like I have shared with you the potential conflict. I find that you understand that potential conflict and that for right now, you're waiving it. You're saying, I'm all right sticking with Mr. Jerome. Is that a fair statement?
Yes.
Okay. If you change your mind at any point, you just need to let me know that, okay? You want a minute? I'm not trying to rush you at all. If you need to think on this, you want to talk to Mr. Jerome about it, that is fine. We had to have this conversation once we could get everyone together. Mr. Jerome was on, I think, last week, but then we ran out of time before we could connect with you. But we got everyone here today. So if you and he need to talk some, we can make that happen. And I'll work on other cases on the calendar, and then we'll get you guys back out here. You just need to let me know how you want to go forward.
Yeah, I'll speak with him I would speak with him.
Want to talk with Mr. Jerome?
Yes.
Okay. Well, why don't we do that? How are we doing in terms of space back there? Would they be able to chat for a minute and we could dive into the next calendar?
Your Honor, we don't need to speak. We've already discussed this. We're gonna move forward.
Okay. Well, I just want to hear that from Mr. Reed. You're okay going forward? I thought you just told me you wanted to talk with Mr. Jerome.
Well, Your Honor, you can understand that the intimidation of the court sitting here and making him feel like something's wrong is going to make him a little uneasy. He's already a defendant in jail who's trying to get out. And so with the court persistently, pestering him about a waiver where he's answered the question about 3 times in 3 different ways, you can understand why it'd make him nervous in a way for the court to consistently and continually ask the same thing over and over again.
No, actually, I don't understand that because that's not what's happened. But the record will reflect his answers that he doesn't want your situation to affect his situation. And I agree with that. And so I just want to understand if Mr. Reed wants a few minutes to be able to talk with you. I didn't ask you, I asked him. So please don't answer for him. Mr. Reed, you are entitled to spend a little time speaking in private with Mr. Jerome if you want to do that. If you don't want to do that, that's fine too. This is an exchange you and I need to have, obviously with Mr. Jerome sitting right here next to you, hearing what we're talking about. I'm not advising you one way or the other. I'm giving you the opportunity if you want it, because we've got all day. But if you want to shift to the discussion of what's happening with your cases, we can do that as well. Up to you.
Yeah, I want to move forward with my case. We're here to speak about my case, not what he has going on with the state.
All right, then we'll move forward with your case. If you need to pause at any time, you let me know, okay?
Okay.
All right, Ms. Charles, why don't you get on the record what you think what the state thinks is happening with Mr. Reed's 4 indicted cases and 7 unindicted cases?
Mr. Honor, based on my last conversation with Mr. Jerome, on the 4 indicted cases, the state will be moving forward on 3 of those. 1 of which is with ADA Thomas, just the aggravated assault. The other 2 with me and their burglaries in the 2nd degree. There are also 7 unindicted cases, which Mr. Jerome has provided me a waiver of indictment for all 7. So we are looking to do a global resolution of all of the burglaries. We were hoping to do something as well to incorporate the aggravated assault. Mr. Jerome and I were discussing as whether how first defendant would apply if we did it all as 1 conviction, or if we just leave the burglaries separate and let the DB case go as it goes. The 18 SC case, 158126, is still moving to null pros, that case.
Are you doing that now, or you would do that following the resolution of the other cases?
Following the resolution of the other case.
Okay.
So we're here for a bond motion. Myself and Mr. Jerome are intimated, since we're so close to go resolving the CP cases and the burglaries, and he has a bond on those. I don't know if that is necessary to do a bond hearing this morning on those cases, because I'm very motivated to get any acquisitions filed and getting the SC numbers for those from the post office. I take a couple of days to get them, and then we can circle back very shortly, take that global plea. Mr. Jerome, I think, mentioned that he might still want to ask for bond on the aggravated assault.
Okay. And would the 7 unindicted cases be accused as 7 different cases, or as 1, or some number less than 7, but more than 1?
There are a handful of them that are very close in time. That may be in 1 accusation, the one that's an outlier may go on some. But I'll try my best to consolidate and merge as much as possible.
You do it however you want. I was just curious what we were looking at. Okay, but you believe you and Mr. Jerome have reached an agreement as to all of the burglaries, which would be 2 of the indicted cases and all the unindicted cases.
We haven't put a final number, I don't think, but we definitely will. We have
Okay.
if we wanted to see whether we incorporate the Agasol as part of that resolution, or just resolve the burglaries and then have the Agasol work the semantics.
Okay. We'll be able to bring Mr. Lee back next Tuesday. That full. She does. We could always try to borrow one from some. Okay. All right. Ms. Charles, we'll go forward with whatever Mr. Jerome wants to in terms of the bond. Our next date where we can bring folks over would be next Tuesday. Would you any reason to believe your accusations would not be ready to go and you've been able to put all the final touches on your offer to Mr. Reed through Mr. Jerome by next Tuesday?
I believe we can get that done.
Okay. All right. Let me ask, we've got Mr. Thomas on the call. Mr. Thomas, anything you want to add from the state in connection with Mr. Reed's cases? You are the prosecutor on position 3 on our calendar.
That's correct, Your Honor. And I haven't communicated directly with Mr. Jerome as to any resolution of this case. I have been in contact with ADA Charles, and I do think that it would be possible to get a global resolution if we just come to the right number. So I'm prepared today to move forward with the bond hearing, and I'll work with ADA Charles and Mr. Jerome to get a global resolution.
Got it. Okay. But the fact that you and Mr. Jerome haven't spoken directly is not an obstacle because you've at least been funneling your thoughts and interests through Ms. Charles.
That's correct, Your Honor.
Okay, great. Well, thank you for being here. So, Mr. Jerome, tell me what you want to try to cover today. It sounds like we are missing because of some administrative work that the district attorney's office needs to do. That point of, hey, let's work everything out where we'd be resolving 4 + 7, 11 cases. Ideally, we could do that next Tuesday, assuming you're available. I need to check on your availability, but we can get Mr. Reed back here. I know we can get Ms. Charles here.
Well, there is still an issue with the DV case. Mr. Reed has some apprehensions about pleading to those. I did discuss the pleading to the burglary charges with Mrs. Charles. I wasn't even sure that Mr. Travis was still on that DV case because he hasn't communicated with me at all in regards to it. I've only been communicating with Mrs. Charles. She's the one who provided me the discovery for it also.
Okay. Well, now you know, Mr. Thomas is in the mix.
Yeah, I apologize. I didn't reach out to him because I didn't even know that he was still on the case. So, that was on me to a certain degree.
It's all right.
Either way, so we are coming to an agreement on the burglary charges, but the DV case is a different situation completely.
Okay.
So we do want to move forward with the bond hearing on that case, and I believe any of those related cases. We do have his family, the alleged victim in the case here to testify here today for the bond hearing. So we would like to move forward with that.
Okay. Well, we'll do that. And it sounds like next Tuesday might still work for you to resolve everything but the DV case. And it may be that the DV case can be resolved by then as well. Maybe that's something that needs to be tried. But do you agree that the burglary cases ought to be good to go by next Tuesday?
Yes, the burglary cases should be good to go next Tuesday being the 31st. Yes, that would be fine for me.
Okay. Well, before you go, we'll make sure you have a time, what time that we'll be doing it. I think we've got a bunch of calendars already. I thought it's a booth day too. Whoa. Okay. It'll be a busy day, but we'll be rested. It'll be right after Memorial Day. Everyone's going to be ready to go. All right. Then let's pivot to the bond hearing whenever you're ready.
All right.
And if you don't mind, it's up to you, but if you don't mind when you're talking, if you have the mask down, it's a lot easier for Ms. Rivers to hear you.
Yes.
That would be great.
All right, and that's fine.
Great.
All right, Your Honor. So we're here on bond for, I apologize.
We're fixed. That wasn't you.
Okay,
It's your fan base.
yeah. All right, so we're here on bond for Mr. Reed. Mr. Reed is a resident of Atlanta. He's been incarcerated since October 31st of 2020. He's been incarcerated for roughly almost 600 days, I believe, at this point. He was arrested on an aggravated assault, family violence, cruelty to children, and some other related charges in reference to a family dispute that occurred at his home. At the time of the occurrence, Mr. Reed did not speak to police. At no time after that has he spoken with them, and has he been given an opportunity to give essentially what is his side of the story to this. Today, we are going to have the alleged victim in the case testify and clarify exactly what happened that day. There seems to be some inaccuracies as to what actually happened to that day, and what was reported or what was recorded in the police report subsequent to that event by the officers who were not there and did not actually witness the events of that day. Mr. Reed is 32 years old. He's currently not employed, obviously, because he's been incarcerated for almost 2 years. However, he does have employment waiting for him once he is released. He is a certified forklift operator. And he does have his GED. He currently has 3 children. His children are living with his parents. 2 of his children actually just graduated from, I believe, from kindergarten this week. Mr. Reed was not there for them. Obviously, Mr. Reed has been missing birthdays and other important family events. His children are important to him, and he's important to them. And so we want the court to really consider the impact that this is having on his family, him not being able to attend these important events and him not being available for them for important life events. Currently, Mr. Reed has no prior felony convictions. So he's not at risk to commit any felonies in this, any further felonies in this case. This is going to be the first, I guess you would say, batch of serious criminal charges that Mr. Reed has faced in his life.
It's a big batch.
It is, and you know, it's a lot to comb through. You know, obviously he has several cases, and you know, some of them are more credible than others. But either way, it's a lot of accusations, and he understands that, which is why, you know, he's willing on, you know, charges that we're not particularly dealing with today in terms of the burglary charges. He is willing to resolve those charges. However, this domestic violence charge is a completely different situation in itself.
Does he, Mr. Jerome, have a bond in every other case other than the DV case? Or I think he doesn't have a bond in his most recent burglary indictment as well. I think he's one where he's got a co-defendant on it.
So he has a bond in all his CP cases. He has 7 CP cases that we've gone ahead and we did the bond hearing on that about a week ago. And he has a bond on all those cases.
Okay.
So it's not a low bond. He's looking at about $150,000 in the aggregate for those charges, which is about 7 cases altogether, I believe. He does not have a bond on the charges that are currently before you. He does not have a bond on the DV case, and he does not have a bond on, I believe, the 2018 burglary charge. That's also been indicted. And so that's what we're requesting a bond on today. Now, he may very well plead to that burglary charge, or the state, as they stated, may dismiss that burglary charge. However, right now we're dealing with a lot of hypotheticals, and we're not sure exactly what's going to happen. So we just want to get some assurances here in terms of bond and his ability to at least bond out. With the negotiations that I've had with the state, you know, there's been really no dispute that the time that he served has already been sufficient. You know, they're not really asking for any additional time. So him receiving a bond wouldn't affect the negotiations in the sense that he'd be released and then they're going to be requiring him to come back and serve additional time or anything of that sort. Everything that we're discussing at this point is just, really probation. And so, I just want the court to keep that into consideration in terms of granting a bond that, the court doesn't need, there is no additional time that even the state is looking for on this. So, Mr. Reed, as I said, he's already served almost 2 years. He's already served almost 2 years on all these charges, being held on these charges without bond. In any case, this is a lot of time. I've had murder cases that have served less time than this before they were actually, taken to trial or pled or anything of that sort. So Mr. Reed is not a danger to intimidate the witnesses in this case. Obviously,
Tell me, the 4 alleged victims are Consuela Mack. Who is that to Mr. Reed?
That is the mother of his children and his fiance.
Okay, and then Markel Reed.
Markel Reed is his son.
And Jakaya Waitha, I probably mispronounced the last name, but Jakaya?
Daughter,
That's his daughter.
And then McKee Mack.
my son.
And that's his other son.
Okay, so his 3 kids and the mother of his kids / fiance are the alleged victims.
Correct.
Allegation is that he shot in their direction.
That's the allegation.
Yep.
Yes.
Okay, so you are free to call a witness. We're not here to prove or disprove the case. I'd ask you to limit your examination of the witness or witnesses to whether they have concerns to their safety or the family's safety if Mr. Reed is around them. But I don't want us to engage in what really happened on Halloween of 2020. That would be, if there's a plea, if there's a trial, we dive into that. But I hear you loud and clear, and it's not new. The defendant has a very different view, and you have a very different view of what went down on Halloween of 2020 than what it might look like if one just reads the sterile language of the indictment. I get that.
Yes, and I understand that, Your Honor, and she understands that this is not a trial. We're not getting into the facts. She's really just going to be testifying to, to a certain degree, she's only going to testify to the accuracy of the police report because she has read the police report. And she's going to testify to whether or not she's in fear of Mr. Reed, whether or not she wants him to be released. Only things that are
The Ayala factors.
Yeah.
Yep. Great. Then let's get it. So is Ms. Mack here?
Yes, she is.
Great. Ms. Mack, if you want to come up to the witness stand, please. Mr. Thomas, will you be handling the bond hearing, or is Ms. Charles going to cover that?
So, Your Honor, I will be handling the bond hearing on the DV case, and I do apologize for appearing remotely. I tested positive for COVID this morning. That's why I didn't come in.
First of all, remote appearances are fine in this era. Second, you better stay remote for a while now. I hope that you are largely symptom-free, and if you've got a family living with you, that they're doing okay.
Thank you, Your Honor.
All right. If we could swear Ms. Mack in.
Can you state and spell your first and last name for the record, please? Cassandra, CONSUELLA.
All right, Ms. Mack, could you give me your address?
3049 Medicine Road, Northwest.
All right, and how do you know Mr. Reed?
He's the father of my kids.
All right, and how long have you known him?
Over 10 years.
And how long have you, and were you guys living together at the time that he was arrested?
Yes.
All right, and how long were you guys living together?
I think I've been there for like 6 years.
All right, and how many children do you guys have together?
3.
And what kind of father has Mr. Reed been?
He's been a great father.
All right, and how have things been since he's been incarcerated?
The kids not taking it so well because they used to him being around every day, all day.
All right,
And do the kids miss him?
Yes.
All right. And do the children ask for Mr. Reed?
Yes.
And do they get a chance to communicate with him?
Yes.
And how do they cope to those communications?
They'll be happy once they speak to him, but then once he get off the phone or once they stop, then they get in their feelings.
All right. And are the children in fear of Mr. Reed in any way?
No.
All right. Are you in fear of Mr. Reed?
No.
All right. Did you read the police report in this case?
Yes.
All right. Is that police report accurate to what happened?
No.
Do you believe that Mr. Reed ever put you in any fear of death or bodily harm?
No.
All right. Were you ever in fear of robbery or rape?
No.
All right. Did you speak to the police officer in this case?
Yes.
Were there any other witnesses there that day?
No.
All right. And it was just you, correct?
Yes.
All right.
The kids.
All right. Without going into any of the facts of the case, is there anything else that you'd like the judge to know?
No.
All right. No other questions, Your Honor.
All right, Mr. Thomas may have some, and Mr. Thomas, I'm sorry, I've been trying to figure out how to get the camera at the witness stand to project. It's not right now. So I don't think you can see Ms. Mack.
I can see Ms. Mack, Your Honor.
You can see her? Okay.
Yeah, I can see on my screen.
Oh, there it is. I'm trying to, it won't spotlight. So it's small. Been trying to make it go as a spotlight. I have a couple questions for Ms. Mack, and then if you've got any, Mr. Thomas, that'd be great. Ms. Mack, good morning. Tell me how it was that the police ended up at your house on Halloween of 2020. Oh, there it goes. If nothing was wrong that day.
I guess because they heard the gunshot, but there was nobody outside. Everybody came outside once they heard the shot.
You didn't call the police?
No.
Okay.
I don't need to.
All right. And you and Mr. Reed were living together at that address with your 3 kids?
Yeah.
Anyone else living there?
No.
Okay. Do you work
I can't work right now.
because of the kids or because you're working through an issue?
Disability.
Pardon me?
Disabled, can't work.
Okay. You say right now, is it a disability you might be able to work through, or you're going to be getting SSDI or something like that?
It's last I began SSID.
Okay. Got it. And what kind of work did Mr. Reed do when he was able to help support the family?
He worked at the warehouse. I mean, at the car wash, and then he worked at Wayfield.
Okay. And your 3 kids are what ages?
6, 7, 13.
Which one is the 13-year-old?
The daughter, the girl.
Is that Jakaya?
Yes.
Okay. All right.
Wayfield?
All right, Mr. Thomas, do you have any questions for Ms. Mack?
Yes, Your Honor, just briefly. Ms. Mack, can you hear me all right?
Yes.
All right, Ms. Mack, I'm gonna need you to speak into the microphone so I can also hear you. And then we can have a conversation. First of all, let's see, when the police showed up, you talked to the police, correct?
Yes.
And you told the police what happened, correct?
Yes.
And let's see, and you said earlier that you did hear gunshots, correct?
I can hear you.
You said earlier that there were gunshots?
Yes.
Okay. Did you ever tell the police who shot?
He told them once he got there, he told them what went on.
He being Mr. Reed?
Yes.
And he told the police what?
He told the police what the incident that happened. He fired up in the air.
He, Mr. Reed, fired the gun in the air.
Well,
Okay.
Your Honor, I'm going to just object to that answer, just on it being hearsay.
Okay,
I mean,
understood, overruled.
Yeah.
Back to you, Mr. Thomas.
Thank you. And let's see. And Ms. Mack, this is like me and you have talked before, correct?
Can you, Mr. Thomas, if you, I don't know if you turn your volume up or speak closer to the microphone.
Okay.
Even Ms. Rivers is having a little trouble hearing you.
I'm sorry.
It's all right.
Miss
You're
Mack-
sick.
Yeah, I am. Miss Mack, me and you have talked before, correct?
I believe so, yes.
Yeah, you remember talking to me last week?
Yes.
Okay. Let me ask you, if Mr. Reed was to get bond today, would he come home and stay with you?
I believe so, I'm not sure.
Well, would you object to him coming home to stay with you?
No,
Is there any reason you have as to why he, Mr. Reed, could not come stay with you?
no,
Okay.
All right. And then do you have any guns in your house?
no,
Do you believe he has access to guns?
no,
And then you also mentioned the last time we talked that he may also stay with his parents, correct?
his grandmother,
His grandmother. That's right. Do you know if his grandmother has guns in her house?
he don't,
Okay. Miss Mack, do you want Mr. Reed to come home today?
yes,
All right, that's all I have.
Do you have any redirect, Mr. Jerome?
No, Your Honor.
All right, Ms. Mack, thank you for taking the time to be here.
Your Honor, so in conclusion, we're asking for, on this bond, we're asking for $10,000. I understand that that may be lower than what the court would usually grant on an aggravated assault. However, well, let's go through it. On the aggravated assault, okay, I'll allow the court to just break it up any way that the court deems to be the most appropriate, but what we're asking for altogether is going to be an aggregate fund of $25,000.
Okay.
So however the court wants to divide that up, we won't be opposed to it.
Okay.
Essentially, we believe that Mr. Reed is not a flis to Reed, is not a risk to flee.
No.
His entire family lives here. He's from Atlanta, grew up in Atlanta. He has nowhere else to go. There's nowhere else he would go. And he has no history of failure to appear or any history of fleeing. We believe that Mr. Reed is not a danger to the community. This is going to be the first, felony charges that he's ever faced in his life. He's pretty much been without issues, without any problems before being arrested in 2020. We do not believe that Mr. Reed is a risk to intimidate any witnesses. Mrs. Consuela Mack just testified herself that she's not intimidated by him. She communicates with him on a regular basis, that they're pretty much on the same page. So there would be no need and no reason for Mr. Reed to try to intimidate any witnesses any other kind of way. And so we believe that Mr. Reed is entitled to a bond and a reasonable bond, considering that he has been incarcerated for 2 years. He's living strictly off the support of his family. And, we're not taking his family's finances into account. However, they did just have his grandfather pass away. And now, I'm sorry, not his grandfather, his grandmother passed away. And now their grandfather is in the hospital. And so she passed away last week. He went to the hospital just a week after that. And so now they're in fear that he's about to pass away, which has already been a financial strain on them because neither one of their grandparents were of any kind of, had any kind of financial resources. And then now having to bond Mr. Reed out is going to be an issue for them. Regardless, that Mr. Reed was working at a car wash in a grocery store, and he does have his forklift certification. And though he may be able to make some money when he gets out, he doesn't have any money right now. And so even at $25,000, that's still a significant amount for him. And so that's what we requested on this bond. And for the charges that are before you, for the cases that are before you, because currently he does have 3 cases before you, the domestic violence case and 2 burglary cases.
He has 4, but he has a bond on one of them already. The old drug case that it sounds like the state will dismiss if there's a global resolution. So you ought not to be worried about bond on that. but the other 3 that are indicted and before me, you're right, no bond.
Yes.
Okay. Has Mr. Reed already posted bond for the unindicted cases? You mentioned that, I think you said it was last week, you were able to secure a bond in those. Has he been able to post that bond?
No, he has not. And, you know, yeah, it's one of the reasons it's too high. And so and just to give you a little insight into the family, they all came together to try to come up with the money for the bond. They didn't come up with the full amount, but then the amount that they did come up with, they ended up using it on the funeral. And so now, you know, they're back
where they ought to have used it.
Yeah.
What is the total bond amount for the unindicted cases?
So the total bond amount for the unindicted cases is, I believe, $147,500. $147,500.
So it's a lot of bond across those cases.
It is. And I mean, hopefully we're going to be able to plea all those cases out, and he's only going to really need to bond out on this domestic violence case.
Okay.
But, you know, honestly, at this point, we're not 100% sure because the state hasn't, you know, they haven't given us a formal offer yet.
Okay. Let me let me try to unpin this because it's still, all right. Good morning, Ms. Jackson. Tell me what you have from pretrial services as a criminal history for Mr. Reed.
Good morning, Your Honor. The defendant has 12 cycles. The defendant's last arrest was October the 4th, 2019, for a failure to appear, and that was in Fulton County. That underlying charge was not listed. The defendant does appear to have open cases pending. It appear to be 4 cases of burglary in the second degree. That case number is 19 SC 173786. And there appear to be 1 for possession of controlled substance, 3, 4, or 5 with the intent to distribute, and possession of marijuana less than an ounce. And that case number is 18 SC 158126. The defendant does have a history of failure to appear. There was 1 in 2020 and 1 in 2019. The defendant has 1 misdemeanor conviction out of Clayton County, Georgia, for criminal trespassing and obstruction of an officer. Nothing in addition, Your Honor.
Thank you so much. And Ms. Tucson, you don't want to be in the jury box, huh? That's all good. I don't think, based on what Mr. Jerome was saying, that Mr. Reed is on probation anywhere. You don't have anything from your system. Great. All right. Thank you both. Ms. Charles, I know Mr. Thomas is handling this, but question for you. Based on the fact that Mr. Reed has been in custody since Halloween of 2020, I take it that all these unindicted cases involve conduct that was before Halloween 2020.
Yes, sir. They range from March 2020 through June of 2020, and then his final arrest in October of 2024.
Got it. Okay. Mr. Tom.
I apologize, Your Honor. When there's an opportunity, I'd also like to give the court some additional information that Mr. Reed wanted me to remind you about.
Definitely. I'll end with you as the movant. You'll get the last word. Mr. Thomas, tell me the state's view as to what we ought to do here and Mr. Reed's situation.
Yes, Your Honor. So you've heard testimony. First, Mr. Reed has 11 open cases in front of the court right now. You heard testimony that he has 2 prior FTAs. We believe that he is a risk to intimidate the victim. The victim testified that if he gets out, he will be living with her and the kids, which were all victims in this case. So definitely a risk to intimidate. And Your Honor, also, we believe he's a danger to the community. The facts of this case shows that he discharged a weapon out of anger, based on the argument that he was having. And he's been accused of discharging a weapon, not only in the direction of his fiance, but also his 2 kids. And Your Honor, like when a weapon is discharged, that bullet can go anywhere. So based on those factors, and Your Honor, it was also mentioned earlier that the state would not be seeking additional jail time. That's not 100% accurate. I haven't given a offer to the defendant, but it would not be accurate to say that I would not be seeking more jail time. So if that figures in, Your Honor, I would ask you to consider that. I would ask that this case remain on no bond status, and that would be set for the next calendar.
Okay, thank you. Ms. Charles, anything you want to add? Because we're actually talking about, I think, two of your cases as well. I don't believe there's a bond on the two indicted burglaries, or is that mistaken?
And that is correct, Your Honor. There is no bond on the most recent burglary, which is ending 21 SC 180131.
Yep.
He does have a bond on the 18 and the 19 cases. However, Your Honor, notwithstanding the fact that we are trying to resolve the case, objectively, I would also join in 88 Thomas's position that at this time bond would not be granted. Mr. Jerome stated in his sort of motion for bond that the premise was Mr. Reed's health. I think he suffered from epilepsy in the jail, and so he needed to get out to get medication. However, it is my state's position that Fulton County Jail is more than equipped to provide the necessary monitoring and medication, and Mr. Jerome is welcome to reach out to them to make sure he's being properly monitored and given the medication. As the record shows, in the summer of spring into summer of 2020, Mr. Reed and his co-defendants embarked on a spree of burglaries while the community sort of hunkered down during COVID. And, taking from the citizens of Fulton County indiscriminately, and the takings and the burglaries stretched from Fulton County well into Cobb County. Cobb County also took out warrants for some burglaries that were conducted by Mr. Reed and some of his co-defendants as well. I'm not sure the status of those right now, but those were part of that spree of activity that Mr. Reed embarked with as well. And so at this point, Mr. Reed faces, a resolution that it's not been finalized yet. We do believe that there is a danger necessarily to the community that he could reoffend. And at this time, we would ask that he would stay in place, first, to protect the community, second, to give us a time to work through where we are at this stage.
Got it. You mentioned co-defendants a few times. I know there is a co-defendant on the 21 SC case, Mr. Owens. Your accusations that you'll be drawing up, will they have co-defendants on them, or there may be co-defendants in those cases, but you are accusing Mr. Reed all by himself so that his pleas to those, if he goes forward, would please resolve those cases?
That is correct. Now, the second part, I'll be going forward with Mr. Reed on his own at this time.
Okay, but you have, for whatever reason, a basis to believe there were other people.
There were other people involved in the.
Are they known to you, or?
Some of them are known to us, Your Honor. They were the people who, I think the premise of this was the co-defendants would rent a storage unit, get a code, and then they would later come back entering the code and come back with Mr. Reed as a passenger, and they would enter the units and break into storage units across.
This is why they're all second-degree burglaries.
That is correct, Your Honor.
Understood. Okay, got it. Mr. Jerome, you said you had some final comments you wanted to make.
Yes, Your Honor. I just wanted to elaborate on the epilepsy, and she did address that already, that Mr. Reed has been suffering seizures within the jail, and what they do is they periodically move him in and out of the medical unit. So when he has a seizure, they put him in med, and then if he doesn't have a seizure for a couple of months, they take him out, and then he has another seizure. So essentially, they're putting his life in danger because they don't keep him in the medical unit, indefinitely to see what happens. They wait till something goes wrong, and then they take him to the medical unit. And he's just afraid that one of these times it's going to be too late when they come and get him.
Is he not receiving epilepsy medication on a regular basis?
Epilepsy medication, but I think the issue is the dosage, that they've limited his dosage, and it's not what the same dosage that he usually gets on the outside. Fortunately, he hasn't had any major seizures in over a year, but still, that danger is always looming over his head. That danger of death is always looming over his head. And so it's a constant fear for him anyway, because he knows that they're not giving him what his doctor had truly prescribed him in the first place.
Okay.
And then on the charges that was just read off, he just wants the court to be clear that that some of those charges have been dismissed. And I just want the court to make sure that he knew or reassure him that those are just charges and that are not that they're not necessarily all convictions that they were reading off.
When you say the charge, meaning when I learned that there were 12 cycles of arrests?
Correct. Your Honor.
Sure. No, what I heard very clearly from Ms. Jackson is that there's one misdemeanor conviction. That's it. Now, there are a bunch of open cases, but open is open and not resolved. So as I understand it, Mr. Reed sits before me with no felony convictions, one criminal trespass misdemeanor conviction, couple failure to appears, and a whole bunch of open felonies.
Yes.
Got it.
And he has resolved those failure to appears. He doesn't have any
Open bench warrants. Okay. I have inquired just for his information if there are any holds out of Cobb.
Yes.
I don't know. I don't have that answer yet, but that's a possibility as well. Doesn't affect what we're doing here because we're talking about Fulton. So, Mr. Reed, we've spent a lot of time together over these many months as you've been trying to figure out what to do with your cases. You've got yourself a lawyer who's sticking with all the cases now, which I think is going to help you out. I'm not going to set a bond on these cases. It shouldn't be a huge surprise. There are two main reasons. The biggest one, the most compelling one, is one of the four factors that I have to be considering, which is this risk to reoffend. I don't know what was going on in your life in early 2020, but you were getting mixed up in a whole lot of stuff that I need to be comfortable that we've put in place a set of conditions on you that doesn't happen again. And that's what would flow from either trial of all your cases, and if you're found guilty, conditions of sentence, or what sounds a whole lot more likely, as Mr. Jerome negotiates with Ms. Charles, we get a final disposition. It sounds like it's going to involve probation, and it's that probation that I'm focused on. What do we put in place in your life so that you've got some supports, that you don't get mixed up in what's gotten you stuck in jail for a long time. And by that, I'm not referring to the case with Ms. Mack. We'll need to figure that one out too, but it's all the others. But I can't in good conscience say, gosh, you've got 7 unindicted cases, 7 different incidents, plus 2 indicted second-degree burglaries and say, let's give this guy a bond. I'm gonna let you say something in a minute. I'm just letting you know, in the face of all of that, I'm not comfortable setting a bond. Second thing is, right now, I don't think you getting out would be hugely productive in the short term. If you and Mr. Jerome are this close, and my fingers are real close together, in resolving all your business, or at least everything but the one case involving Ms. Mack, you need to get closure on that. And something getting out for a minute may cause you to think about things differently in a way that's maybe not most productive for you in working everything out. And currently, you aren't able to make the bonds you have on your unindicted cases. So I will share this with you and Mr. Jerome. Number one, we're going to be back here next Tuesday to see what you've worked out. Maybe it's all of the cases except for the one with Mr. Thomas. Then we need to talk about bond again. We don't need to have this whole hearing, but we need to talk about bond. If the only thing left unresolved is the ag assault case, then we'll need to talk about, well, what is a different horizon? What's that look like? Number two, if for some reason next Tuesday you come back here and say, I don't want that state's deal. Okay, we'll set these down for trial. And if you post bond on those unindicted cases, then we should talk again. But right now, I could set a $1 bond and you're not going anywhere because you got to make $100 and something thousand bonds across those other cases. But if Mr. Jerome reaches out to my staff to say, hey, we've actually here are the bonds on all those other cases, then let's talk about these. But a $1 bond or a $100 million bond on the cases that are indicted right now is not going to change anything because you haven't been able to make bond on the other ones. If that changes, then we should talk again. I think what's going to happen next is that on Tuesday, we're going to be able to resolve everything or everything but the aggravated assault case. And then we should talk again about what that means in terms of release. Mr. Mr. Reed really wanted to say something. Why don't you say it to your lawyer first? Because Mr. Jerome may say that's not something you need to share with the judge right now.
Okay, they fall under the case that he's dealing with now, so they don't seem crazy.
So when we come back next time, he's gonna have all those cases together. All right, Your Honor, it's nothing.
We're good? Ms. Charles, anything else? Mr. Thomas, anything else?
That's all. Thank you, Your Honor.
All right, Mr. Thomas, do you have anything else on the calendars today?
I have a few more positions, Your Honor.
All right, I was going to say go lie down, but you got to stick with us. Don't be surprised if Mr. Jerome reaches out to you. It sounds like he's mostly been working with Ms. Charles, but hopefully the three of you can connect. And Ms. Charles, I'll rely on you as the point person for all these cases. Just keep Ms. Nelson posted. If for some reason you know nothing is working out on Tuesday, we don't need to bring Mr. Reed over here. I don't mean for him to ride the bus unnecessarily, but we're adding him to our calendar on Tuesday. And if I hear nothing, he'll be brought over and we'll deal with this when you can be here in the morning, Mr. Jerome. Okay? All right. Thank you, everyone. Ms. Mack, nice to meet you. All right, I'm going to call our plea and arraignment calendar and our inquiry calendar, see who's here, who's on bond. I know we've got some folks in lockup, some of whom are upstairs, some of whom haven't been brought up yet, and that's okay. We'll just make a plan so the deputies can figure out how they need to shuffle people around. Hold on. I saw your question. When Mr. Jerome pops out, we'll ask. Because it'll be easier to do it Zoom, but it's just the way this is played out. All right, our first position, we'll start with plea and arraignment calendar, is Mr. Hill, who is here but is downstairs. And Ms. Feely, that's your case.
That is my case, Your Honor. It'll be a waiver.
Good morning. Oh, do we need to bring him up?
I don't think so, Your Honor.
Okay. Ms., I don't know if your microphone is on. Ms. Hall, were you able to hear that?
Good morning, Your Honor. Yes, I was able to hear it.
But you don't need to hear it because it's Ms. Patel's case. She's shoving you out of the way.
Great.
All right. So Mr. Hill is a waiver. It's fine to bring him up. It'll be a minute, but we're here all day.
Judge, I think it might be best if he is brought up, just
Okay.
because I know Ms. Bray had the case and then Ms. Markowitz also, and so
Okay. Brought up for you all to chat with him, or is he going to need to come out here?
he won't, I don't think he'll need to come out. We'll just
Okay.
attach him to that.
So just work with Deputy Gordon, and when things are calmer, he'll get Hill up, but there's no sense of urgency on that as long as you guys are still around.
Thank you, Judge.
But so we're all clear. Mr. Hill is waiving arraignment. We'll enter a scheduling order. Ms. Patel, if you haven't already, you'll start pushing discovery towards Ms. Feely.
Yes.
All right. I think that's all we need to do. Ms. Feely, anything else?
Nothing.
All right, so I'll write waived. Done with that. Position 2 is Ms. Singer. Ms. Singer is here. She is downstairs, but we'll bring her up. And you are?
Yes, good morning, Judge. My name is Lauren Brown. I was hired and filed into the case yesterday. I did file a written waiver, but knowing that Ms. Singer had been produced from the Department of Corrections, I wanted to come in person.
Great.
I think meet Ms. Charles. And then if I could, I'm happy to be as patient as we need to be. I'd like her to be brought up so I can meet with her. And if I could inquire whether her production order has the intention of holding her here in Fulton County or whether she's going to be produced and returned, just so I can make accommodations.
Great responses and announcements and good question. Were we planning on holding on to Ms. Singer or sending her back? Okay. Our goal was to get Ms. Singer here. She's been hard to track down, not her fault, so that we could get the ball rolling.
It's a drug case, not a self-defense case. It's not like necessarily I need to have a super deep conversation with her.
Right, but we will do with Ms. Singer what we're going to do with Mr. Hill, which is get her up here as soon as we can accommodate that. I'm pulling up her case just to make sure. Your waiver is in. You are now listed as lead counsel for Ms. Singer. So Ms. Charles well, two things are going to happen. There'll be a scheduling order that gets entered. It'll get zapped to you electronically. That'll have deadlines for the state to get you discovery, for you to file any motions that would require a hearing, and then there'll be a status hearing date. We'll all reconvene for that. I'll figure out, hey, is this working out? Is there something missing? State will let you know their final best offer, et cetera. And we'll keep moving. But if at any point you have figured out a non-trial resolution, we are able, if Ms. Singer waives through you, if she's back in DOC, to take a plea. She'll just appear on a screen. You can be on a screen, you can be here, but we do that, I won't say all the time, but DOC has been real smooth with plugging folks in with Zoom. So don't despair. If you're like, wait, this is a great deal, she wants it, but it's gonna take forever to get her back here. We can also do it remotely if you're waiving her presence here in court. Perfect. All right, nice meeting you. Thank you. Are you taking lots of cases in Fulton?
As they call.
Okay. All right, because we're looking for C3 lawyers as well.
I was made as such an offer, Judge. I cannot make that work.
No, and I don't know who could. I mean, my kids would do it because like any amount more than 2 digits seems like a lot. But you wouldn't want my kids as your lawyer. They'd be entertaining, but it wouldn't work out well. So, okay, you bet. Position 3 is Ms. Hall, also produced today, also downstairs.
Judge, I do need to speak with her and I need to get with Mr. Thomas. I'd like to see if we can work this one out today.
All right, Mr. Thomas, did you hear that?
I did, Your Honor.
Great. So when we're done working through the calendar, just calling it, Ms. Woods probably step outside and give you a ring and see what we can do. We do have Ms. Hall here. All right. Position 4 is a probation revocation hearing with a Cassandra Reed, who is here downstairs. I've got Dennis Scheib listed, but I bet that's not.
We couldn't find the warrants for.
Oh, everyone's shaking their heads.
There's an order in Odyssey that shows that this probation was actually closed out last year. I talked to Ms. Tucson. I think this was a misdemeanor probation matter anyway.
I'm glad we produced her all the way from wherever she got. But wait, it says there's an, oh, that's an even older case.
After we realized it.
Okay. There is from the judicial, whatever it's called, the completion of 48 months of probation.
I think this is before that. They didn't have that documentation.
So why is she in jail?
She has a
new case, Judge.
Oh, in Fulton County,
Yes.
just not ours.
Yes.
Oh, okay. Do you want Ms. Reed brought up just so we can explain to her what's going on, or this can just be a misfire and she don't need to come up?
Judge, her attorney on the other case had reached out to me. That's how I figured all of this out.
Okay.
So I don't need to speak with her.
Great, we're done. So Hall, we do need to bring up, but Reed can go back. Is Gordon jotting that down, or you're just going to remember? You'll tell him, okay. Dondre Frazier.
Your Honor, it's my understanding that Mr. Frazier had been represented by attorney Derek Wright, who withdrew back in 2021. And I also did some research and found that Mr. Frazier is currently in the Blasto County Correctional Facility in Texas. I'm sorry, Your Honor, in Knoxville, Tennessee. I'm sorry, Knoxville,
Okay.
Tennessee. And if I can approach, I would just hand you this document.
Sure.
He's serving a 10-year sentence.
Oh. Huh. All right. So he needs a lawyer and he is busy.
Yes. So I don't know if we can produce him, and if there's a way maybe put him in judicial hold for the time being. Not sure how-
We'll work through that. He also has a warrant, so he's going nowhere fast. But that explains why he didn't walk through the door. He's got a second case. Is that also with us?
So the second case was with us. It belonged to a different courtroom. That case was now crossed back in February, but we still have the open CP and the indicted in this courtroom.
And the CP case, which is older, is from 2020. What kind of charges are those? If you don't know, it's
I have it printed in front of me. I got it to Ms. Nelson.
Okay.
I'm sorry. But I believe it was aggravated assault. It was a mix of charges with obstruction, I think ag assault, there was some drugs. It was a mix of charges. In there as
okay.
well.
So Ms. Feely or Ms. Wood, how do we work through whether if we track Mr. Frazier down, maybe because he's serving 10 years in Tennessee, if that's how it's playing out, this is a case that could be worked out. He is not represented by Derek Wright anymore. He may not be eligible for your representation, but if he is, how do we help create a connection for you guys?
I'm sorry, I missed it. He's in custody where?
In
Tennessee.
Knoxville, Tennessee.
So I
10
guess-
years.
Serving a 10-year sentence.
So if he gets produced, we're happy to speak to him.
Okay.
Once he's here.
All right. In Tennessee, no Derek Wright. Done. Mr. Anjurin, you can come on up. So position 6 is Ms. LaSalle, Sandra LaSalle.
Judge, this would be my client. There's no address in Odyssey. I believe she's unhoused. I did speak with a family friend. If we could have a reset, the family friend was going to try to track her down.
Okay. If we do it sort of one cycle of publication, I don't know why we would publish it again since there's not an address, but how far out do you want it reset?
Judge, I know we have some calendars coming up. Could I have a 2-week reset?
Sure. And it may need to be at least that long. It's 2 weeks. It'll be a little longer than that because we'll want it to be on a calendar.
Thank you.
All right, so reset. Really, it's not so much for notice as investigative search.
Yes, Judge.
All right, position 7 is Quachez Dawson. Is Brian Howard?
I think it's a private attorney, Judge.
Is Mr. Jerome still back there?
No. Yeah.
Did he go out the other? I just missed him, I guess. Okay, all right.
Did you name that?
No, I was going to ask about, and it's not critical, just whether he wanted his client to appear in person or virtually next week. Oh,
Want me to check?
that'd be great if you don't mind. Hey there.
Just assistant board.
He needs it.
Francis is wrong. You can sign it from Samantha.
Okay, I will definitely sign it. And we'll see if we can get him here. All right, so Mr. Dawson, I need to look that up. Let's make sure he's not on the call. 5 Deidre Nelson's on the call. Nope. Okay. Why did it come from non-complex? It's ag assault anyway. Oh, it shouldn't have gone to non-complex. Oh, hey, Mr. Drum, I didn't mean to leave you hanging like that. Next Tuesday, we're actually going to have both booths at the jail and some people brought over. So just wanted to know if you had a preference. It may be easier, given that you're pulled in lots of directions, to have Mr. Reed appear virtually. He's done that before. But because there are a lot of moving parts, because it may be a plea to a lot of different cases, it's fine if we bring him over. I just wanted to know if you had a preference.
I anticipate that this is going to be a plea, so I think it'd be better if he was actually here. And if it's not going to be a plea, we know this week, and I'll let you know in advance so that you don't have to bring.
Great, please do, because bus space is at a premium. The Zoom space is much more expandable. So if you know it's not working out, tell us. If we hear nothing, they'll be produced and we'll take the plea here.
Okay.
All right?
All right.
Thanks.
Thank you.
You guys can come look at you're free to go. IT folks can come look at this bandwidth situation. I tried to get Mr. Anjurin up here, but he ignored me. Thank you for getting Mr. Jerome. I don't know if it's still doing it, but we had a witness testify and all of a sudden the screen got real small and it said bandwidth. I've never had that. You have that with remote folks, but this thing was saying low bandwidth. Okay. All right. I think we're good for now. Her testimony, she kept freezing up on the screen. I'm like, and we had someone remote who was asking questions. So feel free to poke around. All right. So Mr. Dawson is a no-show and his lawyer did? Okay. All right. How about Monte Wadley? He is here. Mr. Shepherd.
Good morning, Your Honor.
Good morning. I bet you don't represent Mr. Wadley anymore.
I'm wrapping up my private cases, but not abandoning them. So this was a hire from long before I even thought about going to work for the GPDC. So I've been given grace to not abandon my clients.
Good. That's the right thing for GPDC to do. So this is alleged conduct from long ago.
I guess it was last year when I got hired.
I'm pulling up the indictment right now. Okay, it's not so long ago, but it was before you wrapped up your more active private practice. The allegation is that something happened in June of last year. Mr. Wadley, you're here today for your arraignment. Mr. Shepherd is on the screen. Why don't you come up to the podium? That way everyone can see everyone. All right, you see Mr. Shepherd?
Yes, sir.
He can see you. Mr. Shepherd, are you waiving arraignment for Mr. Wadley or does he want to be formally arraigned?
We're going to waive formal arraignment, enter a plea of not guilty.
Ms. Hall, are you handling this case in Mr. Whitenauer's absence, or is Ms. Patel also taking this one?
I'll be handling it, Your Honor.
All right. So Mr. Wadley, you're waiving arraignment and entering a plea of not guilty, which means I'll be entering a scheduling order soon that sets some deadlines for the lawyers. The prosecutor is going to need to get discovery to your lawyer, Mr. Shepherd. That'll be police reports, if there were statements made or something was put on film. Mr. Shepherd will get all that. He'll talk to you about that. He'll share that with you. And then you and he will decide if Mr. Shepherd's going to file any motions. If there are motions that require a hearing, that'll be the next time we're together, because the state may need to convince me that the statement you gave the police was legally acquired if you gave a statement. And that's something you and Mr. Shepherd will work through. Otherwise, we'll get back together to make sure everyone's got everything. Is the case ready for a trial, or is this going to be something that resolves short of trial? Mr. Shepherd is your point of contact. So if you've got questions or concerns, or why have I not heard anything for a while, you reach out to him. Do you have a way to reach him?
I can get the contact information.
Okay.
Actually, I tried to call him today and got a different human, so I don't have a good contact number for Mr. Wadley.
I had got a new number.
He's got a new number. So what we're going to do is we're going to share numbers. Mr. Shepherd, what number? Mr. Wadley, you have a way to write something down or punch in your phone if he gives you a number right now?
I can put it in my phone?
Yeah. And then you're going to give him a number. I will have observed the swap. So when are you ready to
go for it?
Hold on one sec. You're giving Mr. Shepherd your number now?
Oh, I can receive his number. I can receive Mr.
Well, tell him your number first.
404 587-3072.
I got 404-587-3072.
Yes, sir.
Excellent. And Mr. Shepherd?
I'll text him my phone numbers in just a few seconds.
Excellent. So he's going to text you, sounds like a bunch of numbers. You stay in touch with Mr. Shepherd. He's got a way to reach you. Ms. Hall, anything from the state?
Nothing from the state, Your Honor. We'll get discovery out to Mr. Shepherd.
Mr. Wadley, I'm looking at your bond that looks like Judge Edwards set. And there was an amendment to it in August of last year. This was before you were indicted. You were allowed to, you had a curfew, but you were able to head out to look for work.
Yes, sir.
I don't know that there has been a change in the bond since then. So let me look at the other bond order to make sure you are current on the conditions. You're staying away from the alleged victim. You've got this curfew, you've got an ankle monitor, and that's it. You're still wearing it?
Yes, sir.
Do you have a job?
I'm still currently looking.
Still looking. Okay. It doesn't have a particular address you have to live at. So as you move around, just make sure you're updating your lawyer so he can keep us updated. Did you get something in the mail to be here today?
Yes, sir. I got it in my pocket.
No, you should hold on to it. I just want to make sure we still have a good address for you. I've got something in Decatur, Spring Trace.
Yes, sir.
That's still a good address?
Current address.
Okay, excellent. Mr. Shepherd, anything else on behalf of Mr. Wadley?
Not at this time, Your Honor.
Excellent. We'll get that scheduling order out and we'll go from there.
Thank you, Your Honor. May we be excused?
You may, Mr. Wadley, you are free to go.
Okay, thank you.
Your Honor, that concludes my business as well. May I be excused until
Yes.
1:30?
Yes, until 1:30. We'll see you then with good status updates on all your cases.
Absolutely.
All right. Let's turn to our inquiry calendar. Position 1 is Demarco Barnswell.
That's my case, Your Honor. I met with him last week, and I believe we are going to have a plea this morning.
Okay, and Mr. Barnswell will be online or coming in?
He's in custody.
Oh, he's in custody. Okay, it lists a bond of like $135. So is Mr. Barnswell up? You don't need to bring him out yet. I just want to know if he's up. You're checking? Yeah.
Judge, he has a new case.
He has a new case, an unindicted.
Okay, but we would be resolving just the old case today?
He is gonna, if it all works out, be entering BHTC.
Okay,
And so.
and the CP case could go in it as well. He's here, great, excellent. We're gonna just run through the calendar and understand what we're gonna do, but he's ready to go, or do you need to speak with him?
I will need to speak with him, and I understand there's paperwork as well. I think I have everything that I need.
If you think he can get through it, if he's going to BHTC, I just flag, we do have a waiver of rights form, which is largely the paper version of what happens during the plea colloquy, but is a little bit more, and it's a good belt and suspenders if someone is in the future trying to challenge the knowingness or voluntariness of his plea. I prefer that we do that, but not if that's climbing a real steep mountain for you and Mr. Barnswell.
I think I prefer to do it that way as well.
Great. So they're over there. If you don't have one, there's a stack of those. So you'll need a minute with Mr. Barnswell. All right. How about Christopher James? I think I get to meet Mr. Granums.
Hey, good morning, Your Honor. How are you doing today?
I'm well. How are you, sir?
I'm doing well. Thank you very much. So Mr. James is positions 2, 3, and 4. We did receive the case. My administrative assistant has requested discovery from Roderick Bridges, Mr. Bridges, but we have not received it yet. I just communicated with her again this morning about it and asked her to reach out to him again.
So that's a dead end. We're going to get you discovery through the DA's office. You're doing it exactly the right way. Hey, why wouldn't the lawyer who had it before get me this stuff? I'll bet you dollars to donuts that you never get it that way with that particular situation. So I'm just looking at the three cases. Ms. Charles, are they all yours?
Yes, Your Honor.
Okay. Mr. Granums, have you met Ms. Charles yet?
No, I have not.
So Ms. Charles is the line ADA here. She handles 85% of the cases in the courtroom. I'm not quite sure why Mr. James had a C3 lawyer if he doesn't have a multi-defendant case, but he did. And so he now has you, and we are very, very excited that you are in the mix. Ms. Charles will be getting you the discovery. Do you need contact information for Mr. Granums, or have you been able to, I guess you guys haven't met, so you haven't been able to connect with him?
I've looked into his entry of appearance. I believe it's all there, so I'll go from there.
Okay. On your entry of appearance, Mr. Granums, does that have a number that is reliable in terms of connecting with you?
Yes, Your Honor.
Excellent. So Ms. Charles will get you the discovery in the three cases. Just looking at the charges, not knowing any of the facts, it sounds like the first one is probably the more complicated one, the aggravated battery, et cetera. The other two may just follow along behind the first one. But we'll get you, the state will get you all that discovery. Should we just enter another scheduling order and kind of reset this?
That might be best.
Okay. Mr. James? Yeah, why don't we do that? I just wanted to get a lay of the land. Yeah, so I think what we'll do, Mr. Granums, in a minute is bring Mr. James out. So you can see him and he'll understand what's going to happen. But I just want to make sure you're comfortable with the procedural proposal that we'll kind of reset all this, meaning we'll do a new scheduling order because there's a new lawyer in the mix. State will have a pretty short time frame in which to get you discovery. You'll have time to digest all that and decide, I've got motions, I don't have motions, and we can press on. Does that work?
Yes, Your Honor. Thank you.
You're very welcome. You are coming in behind lawyers in almost all your cases in my division. So we may be repeating this process as your other cases appear. I think with some of the other C3s whose cases you've inherited, you'll have more success getting their case file, and their case file might even have some synthesis of the discovery. But it may be that we have to reset things a little bit. I don't want you to feel pressured, but we'll be leaning on you because a number of the cases you've picked up, these young men have been sitting in jail, unable to move their case because they have been effectively unrepresented for now a half a year.
I understand.
Excellent. Okay. So we'll get Mr. James out in a minute. Let me just get through the rest of the calendar to see what we're doing with the others. Position 5 is Mr. Hightower. Is he in custody?
No, Your Honor. No, Your Honor.
He was supposed to walk in.
He was given PTI, failed to complete, and I think the last time we were here was coming to see whether counsel had been retained or appointed.
Okay. Let me just look up his case. Mr. Ogun, do you need, you've made it a hard wire? Okay.
I'll come make it look nicer a little
Later. Okay. Excellent. As long as you come back when we're down and make up the red cord's kind of cute, but I just don't want Ms. Rivers tripping and suing you as she gets in and out of her space. Excellent. Thanks for the quick fix.
Hey, Your Honor, that concludes my business. May I be excused?
Anxious to get the, no, because isn't there a plea?
There's,
No,
I
Your Honor.
talked to him about an offer, Judge, for Ms. Tila Hall
Yeah.
from
Oh.
Mr. Thomas.
Yeah. If you want to take a break, but you can check your email. I could have Ms. Nelson email you, but if Ms. Hall wants to work her case out today, we'd want to do that because we had to track her down.
Okay. That's fine. I'll just hang out.
Okay. We'll get her up here in a minute. Let me just figure out what's going on with a couple of these other cases. So Ms. Hightower is not here. 16752. Oh, because it was a PTI fail. Okay. Got it. Okay. Then we will do a bench warrant and I'll go to judicial hold. And finally, we've got Raheem Conley. Is he in custody? I can't tell. He's on also the add-on where he's got a bond. It doesn't say anything for the other one. You don't think you have a Conley?
No, and I also don't see an attorney having entered an appearance either from Mr. Conley.
Well, he had his older case that caused the new one to come to us was the conflict defender. It was Mr. Webb, but that would make it not Mr. Therry's case, but John, the other guy.
Judge, if I could make you aware, I submitted the official conflict for this case and I got notification yesterday that they're changing up the conflict rules again. So they're not going to take this case if there's not an actual conflict, which presents an issue for our office. I don't have a file for Mr. Conley, so he was to show up today. I was just going to talk to him.
Yeah.
But I just want to let you know that that was the word from GPDC.
So just so I can process that, because that will likely lead to some conversations. His older case, there was some conflict because Mr. Webb was assigned to it. But what you've been told is because there's no conflict with the new case, your office has to keep it. The conflict in that other case isn't contagious, basically. So Mr. Conley's going to have two lawyers.
That was the directive that I received when I submitted the request.
And these directives come from your office or they come from the GPDC?
My understanding it was GPDC, Judge.
Okay, that makes more sense. So there was some funky consent bond order for Mr. Conley's older case where he had house arrest and an ankle monitor. He should not be hard to find. You got a signature bond on the other one's an old case, which is the new indictment. Okay, we'll look into that. He should be here. Let's bring Mr. James out, please.
Judge, that concludes my business. May I be excused?
Yes, ma'am. Thanks for being here.
Thanks.
It concluded a while ago. Thanks for sticking around.
Thought I'd just hang out.
All right, this is the place to be.
It is.
8D. We've got a little cake cut machine in the jury room. So Mr. Granums, I'm gonna make you big on the screen.
Okay. Huh.
James, if you come up to the podium, please. How you doing?
I'm all right, Jan. How you doing?
Well, I'm feeling a little more optimistic for you right now because we have at long last been able to line up an attorney for you. The gentleman you see on that screen right there is Mr. Granums, and he has been appointed to represent you on all three of your cases that we've been stuck trying to get a lawyer for you because you had Roderick Bridges, and then he stopped practicing criminal defense. He actually works for the district attorney's office now, so he can't represent you anymore. He's on the other side. Not so with Mr. Granums, and he is picking up some of Mr. Bridges' cases and some of the other lawyers who were doing the kind of work that Mr. Bridges was doing. I just want to share all that with you so you could see the gentleman who's your lawyer. He will come see you soon. We need to get him discovery in your three cases because Mr. Bridges has been a little sticky with that. But Ms. Charles, the prosecutor, We'll be getting all your discovery to Mr. Granham's. He's going to digest it and he's going to want to come talk to you to say, hey, I looked at this stuff. I think there may be some motions I should file, or we need to take this one to trial. That's a bad case for the state. Or you're caught on video doing whatever happened. I'm making all this up. I don't know the circumstances of your case. You do. Mr. Granham's will soon. You guys will talk after Mr. Granham's has charted a course. Hey, I want to argue these motions, or we want to work it out, or we want to trial. Get you back in here and do one of those things.
Okay.
So it's good news. It's just taking a while. Everyone's having trouble finding lawyers. I'm very appreciative of Mr. Granham stepping up saying, hey, I'll take some of these cases. And he is. So Mr. Granham's, what can you tell Mr. James as to when he ought to expect connecting with you to talk about his cases?
Yes, Mr. James, first, it's nice to meet you. And I look forward to actually meeting you in person and not over this screen here. But I plan on coming out with my investigator to see you one day this week. It'll definitely be this week, okay? We'll come down, we'll talk to you. And like the court said, at this point, I don't have discovery, so I don't know exactly what evidence the state has in this case that they're intending on using. But I'd still be happy to talk to you, to get to know you a little bit and at least share some of what you can tell me about it, okay?
Okay.
And at a minimum, Mr. Granham's, you should be able to grab, I assume you've got Odyssey access. Have we afforded you that?
Yes, we do, Your Honor.
All right, so you're gonna know the basic charges and whatnot. Ms. Charles, if there's a way you can get, in particular for position 2, some of those materials to Mr. Granham's ASAP, I assume that's the one that he and Mr. James are gonna want to talk about the most. But it sounds like Mr. Granham's is more than willing to have the get to know you visit this week, maybe with less info. And then once he's got all that discovery, get back to the jail and see Mr. James. Mr. James, are you at Rice Street or are you in Cobb?
I'm at Rice Street, sir.
Good. All right. Just want to make sure they go to the right place. Wow, we've got almost every deputy from Fulton County in here now. All right. So Mr. Granham's, you'll see Mr. James soon. You'll see some discovery soon. We'll enter a scheduling order in all 3 cases so everyone has the same roadmap. All right?
Thank you, Your Honor.
Great. You're welcome. Good seeing you.
All right, thank you.
You too. So let's recap where we are, because that's all the cases for this morning. We need to bring Ms. Hall up. We need to bring, Mr. Barnswell is up, so you'll talk with Mr. Barnswell. Oh, we were going to bring Ms. Singer up, so we're going to bring up Hall and Singer, 2 females. And you want to talk to Mr. Hill?
I've spoken with Mr. Hill.
Oh, you did? So Hill can go down. Reed does not need to come up. She told you that already. So we need Singer, Hall, Barnswell is up here. You'll talk with Barnswell. And that's it from these calendars. So if you have other people up, they're on the afternoon calendar. So you may need to do one of these things to fit these other people up. And then because we're now ahead of schedule, you'll have time before the 1:30 to flip people around if you need to do that. Does that work?
Yes, sir.
All right. So I'll step off the bench. I'll come back out if Barnswell is ready to go, when Barnswell is ready to go. If Hall is something we're going to work out. And Mr. Brown, once you've talked with Ms. Singer, you're free to go. You and I don't need to bug each other again today. All right. Great.
Thank you, Judge.
Who do we have online? So Mr. Thomas, I guess if you don't mind sitting tight, Ms. Wood will make talking to Ms. Hall a priority, and then she'll pop back out here to let us know we are going to do something or are not. If we are, then we'll keep you online a little bit more. Otherwise, you can go lay down.
I appreciate it, Judge. And Ms. Wood, feel free to give me a call on my cell phone too. It's on my email signature.
Oh, okay. Thank you.
Great.
All right.
Okay. So Ms. Jackson, if you don't mind staying on, because we'll have 1 plea, maybe 2, and then we'll all take a break until the 1:30 calendar. See what's happening with that one. Okay.
Okay, Judge.
Thanks, everyone.
So y'all taking a break at 1:30?
No, I'm taking a quick break. I'll go back there and do some stuff, but we have a plea likely. They just got to sign them up. And then maybe a second plea. But when those are done, then we're down till 1:30.
I'm gonna talk with the DA and then.
Yeah. Maybe we can reach out to, look at that order again.
That's my only one. It's to the hall. And then Mr. Brown has.
I don't know if he has pretrial supervision or not. Yeah, because it was this funky order I did when the guy who I don't think is at the DA's office anymore. We do. I'm just embarrassed if we didn't have pretrial services, because who then would say that the ankle monitor is still working? Let's ask. Hey, Ms. Jackson?
Yes, or she's on for she'll end up getting a violation, but she's not on probation.
Ms. Jackson?
Yes, Your Honor.
I know I said we're taking a break, but question came up about Mr. Conley, who is the only position on the add-on calendar. But he is also, depending on which calendar you've got your hands on, he's position 6 on the inquiry calendar. Same guy, 2 cases.
Okay, Your Honor, I did not receive the inquiry calendar. I have the plea and arraignment, and I have a status hearing.
Okay. If I give you an indictment number, can you look at, we're trying to figure out if he's subject to pretrial supervision. He's got an ankle monitor, and he's not here. And I thought, well, we should be able to fix that. But the bond order didn't say pretrial supervision. And so he may be one of these where there's an ankle monitor with no one monitoring it, which.
Okay. Can I get his name and his case number, please?
Yes. Last name is Conley, Conley. And the first name is Rahim, Raheem.
Okay.
Case number 21 SC 178070. He has a second case, but that one I think has a signature bond. So I don't think you all would be in the mix on that, but let me look.
Exactly what is it that you want to know on Mr. Conley, Your Honor?
Well, whether you all are supervising him.
Just a moment, please.
You taking over the podium?
Am I on camera?
No, Ms. Toussaint was up there.
Yeah, so, okay. I think he has, okay. Yeah, and then that is C3 conflict. That person has like a bunch of open cases, and then conflict, and then. Oh, that would be your difference. That's Cassandra. Okay, so yeah, I just sent it to you. You're welcome.
She's not in your status or anything. I don't see any recent case notes, but did she go back to the meeting? Okay, because she does. Because, it's the same, same everything, but it's just showing that she's in custody. But I don't see any,
The defendant is not being supervised by pretrial services, Your Honor.
That was my fear. Okay, thank you so much.
yes.
So I don't know how we,
His bond. He's got different address in his bond.
Thank you.
the Fairburn Road, Department G3.
Lacey, can you say it again? For some reason, when I clicked, it disappeared.
Okay,
That's not good notice, right? Because in the order,
at G3,
Hall. Tila Hall? No, that's Lacey's.
which is the address for the 21 SC case, the add-on calendar. Did he get notice for this?
21 is like the Donnelly Avenue.
I'm looking at the 21 and it lists.
Is this your first case? Oh, sorry. And the one in the 22, let's see, went to Oakley. 6355 Oakley.
In the 22 or the 21?
22.
Okay, but did he get notice for the 21?
21 went to Dondre.
What? That's not even, I'm looking at the case right here. That's weird. That's not even in the system.
Good morning, Judge.
Hello.
Yes, Judge. This is Alex Ark. I'm the attorney for Quachez Dawson. I apologize for my attire. I'm actually down in Florida on a family vacation. I did not know that my client and I had court today. I guess there must have been some mix-up either at my office or with notice. But I'm just asking to waive formal arraignment and enter a plea of not guilty. Again, I apologize for my appearance this morning, but I just got notice from your office.
Okay, hold on one second.
Sure, not a problem, Judge.
This is the 21. Let's see.
Okay, but look at what's in, I don't know where that address came from. If you click on the individual. Okay, go back to parties.
So.
Doesn't it list the Fairburn Road thing or not?
It does list it, but that's not where this notice was.
Yeah, so I'm just wondering where that address came from. All right, let me restart the video. All right, so Mr. Arca, I'm getting it now. So Brian Howard, I guess, is your law partner.
That is correct, Judge.
Because his name is on the calendar. Notice would have gone out to your firm at East Church Street in Douglasville. Notice would have gone out to Mr. Dawson at whatever address he has maintained, which is looks like an Oakley Road in Union City, because it was a notice calendar. It is plea and arraignment. So this is a less critical thing for Mr. Dawson to have missed than, say, his trial or whatnot. But
correct, Judge.
It is time to move the case along. Have you had a chance to talk with Mr. Dawson about whether he's willing to waive formal arraignment or if he wants to be here in court to be formally arraigned?
No, Judge. He waives formal arraignment. We've represented him on the cases that he's currently got pending in Carroll County. So it will be a waiver of formal arraignment, Judge.
Okay. What I'll need you or Mr. Howard to do is to file a waiver of arraignment. I'll have Ms. Nelson send you all that form that we use. And then one of the two of you will need to e-file that. We'll get a scheduling order entered. You'll get that electronically as well. That'll set out the deadline for the state to get you discovery and your deadline for filing motions. It's keyed off of that scheduling order and not the 10 days from arraignment or anything like that. It's further on down the road because you need to get the discovery first.
Understood, Judge. And I'll get that filed in today, the waiver of arraignment, as soon as I get it.
Okay, excellent. And that'll be how we proceed. If you have questions or concerns, just reach out to my staff, okay?
Will do, Judge. Thank you so much. And again, my apologies. I
All
don't
right,
like this habit.
enjoy Florida.
Thank you, Judge. Have a good day.
All right, bye-bye. Pretty nimble. So no bench warrant for Mr. Dawson. You all are waiting for people to be brought up?
Yes, Judge, and I just got an offer from Mr. Thomas, so once she's
Great.
here, I'll go talk to her.
Okay. And Mr. Barnswell is up. Have you had a chance to meet with him or you're going to be doing that?
I have met with him. I'm going to just go over one more thing with him briefly. I think we should. be
Okay,
ready to go.
then I'm going to briefly leave the bench so I get a chance to do that and I'll come back. So what do you think happened with,
I was looking to see if they pulled it off, just, maybe from when they booked them in.
but I thought the way Odyssey was supposed to work, there's that correspondence address and it just automatically pulls from there.
It should have, I don't know. For some reason, when I had that done.
Yeah. So I don't think bench warrant is correct.
No, I don't think so. But I just don't know why it's not. So.
Yeah. Oh, well, maybe the clerk's office could explain, because we don't want that to happen in other cases.
Okay. Can be, you have to do much higher less paper. Because. So. Practice.
Right. Yeah.
So you have to do this. This is like my personal. That creates a 15 days. It's not, you know,
I was just curious. If I-
Hello?
be at this.
So I'm just here also.
Hello?
Yes.
Yeah, this is Mr. Dawson. They said I was supposed to have court.
Oh, we just finished with your case.
Yes, good morning. It's 88 Charles Street.
I didn't.
We just talked to your attorney. We just finished your case. Your first name is what?
Quachez.
Right. Yes, you're okay. We're gonna enter a scheduling order and you'll get notification of your next court date.
Okay, so I need to talk to my attorney to see what happened.
If you change addresses, you need to notify the court.
Okay, I thought I gave you. Oh,
Did you get notice for today's hearing?
no, ma'am. I didn't.
Okay, hold on a second. Let me go and see what address we have for you. Oh.
I think this is my lawyer calling now.
In my house, actually, when I'm out. Closing on my new house tomorrow. Yeah, closing on it tomorrow. I mean, it's just supposed to.
Do you still live on Oakley Road?
It's townhouses in France.
Ma'am?
Oh, yeah. Oh, yeah, well, school. I'll use it since she's there.
Oh, some versus the body. The Rachel told me he was.
The star signs.
Taking my poison pill. You know.
Yeah.
There's no scheme. It's like a pullover on this one. Is there one? 1 second.
How are you? Good. I'm watching.
Probably made just to get it so that I can adopt it.
A whole lot of everything going on. It is, a lot today.
Oh, okay, yeah, I thought a preliminary one yesterday. I have a friend. I did. I think she's sitting on it. That's it's like pull over some. You got the right car. It's like get a car half immediately. They don't even understand English. And it's like go search it.
This is all over.
Fayette County sucks. It's suspicion for non-citizens. They do not do driver's license. Like, yeah. Not even an accident. I just try to help her. Yeah.
Okay.
The place that's there. This is awesome. Whitfield County is awesome.
Ms. Feely, I just remembered I have an 11:30 call I have to take. So if you think we can do Mr. Barnswell between now and then, or you want to start that, we should. Otherwise, we won't be able to do stuff. It's about a half-hour call.
I think we can move forward at this.
Okay, we need Ms. Charles.
So what we're doing is after everything goes through.
The arrest citation. Interesting.
To Ms. Nelson, that then she'll get Judge McBurney to sign them and then.
From 2 years ago, almost. Yeah, no, it's from a year and a half ago. But where's that? That's, oh, I see. It's not even the address he gave.
And then I'm talking to her. That's normally. Hold on for a second, Judge McBurney might want to.
We're ready for Miss
Barnswell?
Barnswell, yeah.
Let me just grab my laptop.
Thanks.
All right. Yes. So we'll do that.
I'm not saying you're right down the wrong.
Okay, yeah, no. That was the one that tried to just talk to.
Oh, that's it. It's a female. Quachez. Okay. Okay. But anyway, position 7.
Yes.
Good.
I need to go to the podium because it's easier.
So reset for notice.
I don't mean to scare you.
No, you
So,
didn't.
I was under the impression that all the males was coming back up at 1. So I went and got both females. and took all the males down.
Oh, I didn't know. Okay, you were under almost the right impression. We needed you to keep that one male because he was gonna plead. But we don't have time. I mean, I gotta take this call at 11:30. So what about Ms. Hall? Do we?
Is she back there?
Yeah.
I'm happy to talk to her now.
Oh, you're gonna talk to her now. So why don't we do this then? Just so we've got a clear plan and folks don't have to wait around. Ms. Singer is back there? All right, so Mr. Brown, you can go see Ms. Singer. Ms. Wood, if you don't mind talking with Ms. Hall. And we're gonna, is it your preference to break until noon when I can be back in here, or just say, let's reconvene a little before 1:30 to take the plea so that we're not late for the one? What if we started again at 1?
That's fine.
Why don't we just say, I'll be back at 1 to, at a minimum, take one plea. And that is Mr. Barnswell. So we need Mr. Barnswell up. And it may be there's a plea with Ms. Hall, and we would do that. And then everyone we need for the afternoon calendar. And we'll just start at 1.
Okay, that one, just go straight through.
No, I thought we were, but Mr. Barnswell ended up going downstairs. So you should be back by 1. And Ms. Wood, if you'll just coordinate with Mr. Thomas, if it is going to work out, that's great. And we'll do it at 1. He can take a break once you and he have conferred. Thanks so much.
Thank you.
All right, Ms. Nelson, I'm gonna talk to you.
What was the reason Ms. Reeves got reset? She's having
She's the last female. Reed, meaning Ms. Reed. We don't have her case anymore. Her case is closed. She's got new charges, but she was brought over on the old case, and it turns out that probation is closed. There was a probation warrant, but her probation's closed out. So,
She only has one case left.
yeah, she just got some open case, and that's it. We thought,
She has nothing before.
yeah, yeah. Yeah, everything's good with us.
Scheduling magic.
Judge, I heard you say you were from California. I am too.
Where?
I am from Palm Springs.
Palm Springs.
So that's important, you know, so I
Really?
just Palm Springs. My whole life, no.
What?
When I was about 30.
Wow. When I was high school, one Christmas break, we went down to Palm Springs because why not? Because I was up in Northern California. Well, it wasn't hot, but it was nice enough we could be in the pool.
Yeah, we only have 2 seasons, hot and mild.
Yeah. So mild is very nice. Yeah.
All the snowbirds come every winter.
Yeah.
From about October to March.
And then they bust out of there because it gets too hot. Yeah. Then it's more like Palm Desert.
But you know, up north is like 9 hours a week. It's a big difference.
It is. Yeah. It's a big state.
That's why when I came to here, I'm like, I could do probation 3 hours. It's like, it's like.
I think we've gone over everything at this point.
Judge will say yes. He'll say yes. I mean, but I'm just saying that I don't like to take non-complex cases. Sorry. I know. Because they end up being ours. I do make a whole like 60 counts.
Right.
But we talked about it yesterday. So I really have to sit it out.
So it's going into, we're gonna take our plea.
So we want to plea into trial. That's why I want to bring everything together. Just plea into trial.
You gonna leave it alone?
Meeting with my probation, yes. That's what I'm kind of looking
So I don't understand why we have to. And let non-complex be. I'm just saying.
I know, that is,
I
that's
don't
the,
think-
that's a.
Because we don't have any. We don't have any, our revocation, it's basically a closing. So when they say, can we?
Do the whole thing.
There's nothing open before us.
To bring it in.
Right, if we have one case, it's the other cases. This is a revocation. So it should, yeah.
So I should give my agreement to the non-complex attorney and let them just wrap it up.
That's what I would do. Now the revocation, you can do the revocation, because that's yours. They
But
probably
it would still be whatever. I kind of want to run the same way, so revoke, reinstate, and just follow the recommendation to your court.
But. Well, you can, I mean, the judge will probably say he'll do it, but that's not the way I look at it. And I don't want you to get back.
No,
He's
because
those.
I said, oh yeah, before you got here, that was the mistake.
No, that's.
So it's like, you did it right. And then I had another case, contagious Jackson, has an open case in Judge Edwards, and he was going to move contagious Jackson over to Edwards because they're setting up a jury to wrap up that case, and he wants to wrap up with contagious system here, over there.
But see, you can't, unless, the way it is if you have an older case, you have a. Then we can. If they have an older case, we can transfer all open cases to them.
Should you write down whenever y'all.
It's not fair.
So, oh, let me go with it. Thank you.
Not gonna argue with her. So what are the, I don't mean to be bent over like this, but,
You're fine. Oh my God, I know, right?
the one of,
It's always so hot.
They have.
I guess when I get for like six.
Cases, I guess they have resolution. But we don't want to look at.
And you're not in the jail?
So, I guess.
What he's telling me is, it's not gonna go. And they could be that attorney.
No, because it's like, and it's a lot of.
Well, she's done a no profit.
This guy has 3 positions, no 4 positions on him.
No
So
profit.
like, he's half the calendar.
Education should be handled.
That's why she was saying, he was saying, this is how him go
Are you
there.
serious?
For the revocation.
For the revocations, and that's from June, it's just not today.
Oh, is one of them contiguous Jackson?
And that was.
That's.
So he's on for probation revocation, but I think that's the first time he's on, he's got private training. So I don't know if that'll go. Where, do you have this?
I have the wrong.
Who's the attorney on that one?
Jackson.
Audrey Simmons.
Oh,
The attorney on Scott Waters.
So they, how many counties?
I mean, And then. So the 19, let's see, 167, 500.
Yeah, so what we'll do.
No, that's our case. That's a revocation,
Yes,
which is the open case.
The open case is 22, let's see. 180, 2.
Oh, yeah.
And she says,
I'm gonna go back and confirm with her. He told me that's what she said, but I'm gonna go back.
Right now. But if it's 10:13.
and so if she tells you she's, then why would we go ahead? The
Because I'm wondering, is
I mean,
the,
the probation.
because I'm wondering, is the revocation based on this case? I have to work. So.
I'm sorry. I'm not putting you on.
No, but this one, the keys.
We got Kentucky Jackson. We got Barnswell, James.
I don't see. I don't know.
This is 130, 135.
And it means that by taking possession of tools.
But Haynes, give her.
This is probably issue.
Oh, that one I think is a plea.
Honor about to.
It's a private attorney.
Okay, what about, Smoker? Cornelius Smoker?
This is unindicted.
That guy is,
That's
a
unindicted.
C3. He was on the Zoom, but I
Oh, so he was
was
on.
that attorney is, yeah.
Chris Davies Smith.
That person's supposed to have that muscle attorney, but none of the conflict attorney showed up this morning. So I don't know what's gonna happen with that one. Is he in custody? Okay, and then John Pierce is supposed to be a walk-in, I think, but that's a conflict as well. And then Ortiz has a private attorney.
So. Yeah. So these, but see, that's. So if they're under the unindicted cases, the cases are still unindicted. So him from this defense side, he's gonna say, they don't wanna go forward because he's still gonna say it. But he can't keep, I mean. So this was filed on December, it's 6 months later, it's still not in that, so. Is it gonna be indicted? Not indicted.
I mean, this one was a good disorder.
So I don't know, because 19, I don't need to. Well, the thing about it, this one, so it's gonna be no promise. And we're gonna be stuck still in the same position because these two need to have the revocation hearings and they're based on the charge that's on there. So I mean, saying that you're gonna send it over there for Judge Edwards to handle it, and you know they're gonna go across the case, and it's just doesn't make sense. Because from the defense side, he's gonna say, even after they know process, they still have these warnings for the CP bill. And he's gonna say.
He can just say, someone said they revoke 6 months times 4. And go to Edwards and get Edwards, and the CP case was indicted. Because where it goes.
But see, the law is knowledge. When you're back at the clinic.
So I should close out the revocations. So I'll do,
Well, I mean, close up the revocations, knowing that, well,
she has to know process, but then I have to because.
I mean, just see, I mean, because that. From the defense side, I mean, I would be looking at.
Yes.
Now, the other one that you were talking about, who is that?
Mr. Smith, the first one. He has a bunch of cases. We need to consolidate this. It's not laws. You know, like from 2013.
This is non-complex, that's a lot of changes.
Yeah, that's what I was saying. We need to just consolidate. He wanted to consolidate all the cases. All of that into charges, a bunch of misdemeanors. And one of them is something that is from looking at charges. One case is. Counts.
Yeah.
This one is to come. 60.
No, when they're out the other hands.
Well, that's the consolidate.
Why did they change transfers to complex based on the severity of the charge? You know, usually they like passing this on. No, I understand that. Like, somebody's not gonna be paying attention to 9%. They just transfer, they don't even bother.
I need to go talk to him.
I mean, you know, we're a bigger, yeah. I mean, if it's raining or not.
Oh, that doesn't make any sense. I mean, that's what I don't understand.
The last time we stayed in here, there used to be a cafeteria.
Like counter, no. It hasn't been on the counter. So they're doing nothing. I guess that's your call. So what you're saying is that what you would do is.
I want to have it set quickly and see.
Is he eligible for justice?
Probably is, right? He was- And so when I came, I was told that was what was negotiated, we just couldn't get it to happen. So,
Yeah.
And then we had it. And Judge said it's into he needs it.
And that's why I said judge will take her. I mean, you know,
And
says
then-
drug court, he do it.
I mean, it's yesterday, 4:20, Mrs. Trump said it's the agreement saying it's an exception.
So you still have to work out the whole.
I'll have to, yes, sit down and just do one run, I don't know what the next calendar is. This is a lot.
What y'all do plans for night? You gonna try to play those? Yeah.
But Bobby, you're.
Yeah. Yeah, I mean, I wouldn't say anything spending money on it.
I mean, do you want to work 4 days a week instead of on for the A?
I'm going to right now.
What is the 31st?
No, that's too cool. The 7th, I already said.
I'm sure it's nerve-wracking.
Okay, just let me know.
Well, that's the Tuesday after. Oh, the Atkins again. On the 7th as well.
Yeah, that's what I'm saying.
Well, why not return and tell him I said hello.
I will, thank you. Good to see you, Lauren.
We're not,
We don't have.
we don't have. Oh. So then we'll see what happens.
Mhm. Yeah. Yeah, you can. I don't know what you're, if you want to get food or what you want to do. There's American Deli on Main Street, there's cheese. Yeah, you can totally leave and come back. Up to you. I don't know what you guys have to say.
It's kind of changing.
Yeah, I'm gonna hang tight, so I want to see if she.
Status won't be that bad for the afternoon.
My lady too.
Usually the afternoon, up so I can find the transport.
It's actually.
Nothing I should be going.
Okay, so we can probably do that.
The afternoon.
Yeah. That works.
Check with Scott, and see if that'll work for him.
Well, he wants it that way, so I'm gonna have to make it work. You can't.
Okay. So we'll say June 9th. Yeah.
Cool, I wonder if she's still up.
They're gonna kill me.
Yeah, sorry.
But that's, I know, you got a lot of
stuff.
We all have a lot, don't you guys like it? We're fired up.
Oh my goodness.
I know, I said, it. I told you, just. You're gonna keep it's all my fault. Okay, so that's what we'll do.
So that's what we'll do, and then I'm gonna go, let me go second talk to Smith and Audrey about the Jackson.
Okay.
I'm scared they took her down.
Yeah, they might have taken
Yeah, that might be it.
switching. One, I could send Gordon a text and tell him that she needs to.
Will you see, I think Paul will take a email, I got a different message back from Mr. Thomas.
Okay.
I would love to resolve the case. We should-
Please.
Yeah, like go back.
I mean, try to get her.
I'll be here. Okay, for sure.
We've been trying to get her for what, 3
Well,
months?
yes,
3 months at least.
Yes.
Okay, I'll send
Thank you.
Okay.
See you in a bit.
Okay, bye. Did you see her email?
She
I mean,
texted me,
text.
but, so what's the? 'Cause-
So now, is she up here?
No, not yet.
Okay.
Let me tell you what she told us.
Okay, what she said?
If it ain't the same what you got going on right now, she's not gonna tell you.
So he said he'd come down, she's got 4 years left on the cab, and he said he'd come down to that, so it could just all run together.
Yeah, that's what, okay,
Let's resolve this case.
Yeah,
You want to go back there? Or you want me to wait?
No, she's not
Okay.
here.
I didn't bring it up.
You gonna have to talk to her again?
No, I just need to like, what, he probably will make her sign up, right? Yeah, it's fine. If she doesn't want to talk to me, then we don't have to. But I just emailed him and then he finally wrote back and he was like, I'm fine with it being 4, which is what it is in the cab.
So what you want, just put her in now?
Thank you.
Okay.
So right now we're in the room to go get it right now.
Thank you.
You don't have any clients that you need to speak to?
So I don't have anyone on the 1:30 calendar.
Lucky you.
Well, did you see next week's calendars?
No, I didn't.
They're like, it's basically all my clients. Yep.
So if she agree, would you need her to agree to that? Or she just have to feel everything all right?
So I don't think he's gonna make us fill out that thing. 'Cause
Yeah,
he's-
she's already.
Yeah, and he's been like kind of lenient on those for certain cases. So I mean, unless she like wanted to talk to me, we could probably just bring her out here and just run it off. So I'm happy to do that. Unless she like had like some question. What happened?
I asked the deal, we need to get, so get that completed, we really need to bring it up.
Who gonna do that?
I don't know, I was just asking because if they're gonna run it together.
Yeah, and if you don't, if y'all could, is it easier? I don't know how it works back there. Can she be brought out and then like right before the plea, like if she has any questions, you know how like last week or the week before he let me just like talk right here, we could do that. I'm happy to do that. That's easier for y'all.
You
talking about for her to sit here the whole time? Well, when we take the plea, she'll have to be like out here, but if
Oh,
like,
she
she
don't-
had any questions, she could just like step back and ask me.
Oh, no, I was saying to take the plea regardless, what she got, yeah, like.
Oh, yeah, yeah, be on record. Why are there so many people back here today?
AC,
Oh.
they got 19.
19
And we got
and
11.
19?
We got 11.
And they still gotta bring up females too, and they don't have anyone, because one guy has to be by himself.
Oh. Okay, yeah. And like all these people that were like on the afternoon.
It's a big status.
Yeah, it's like a status. Great. You guys, like, Cassandra Reed was taken back though, right? Mr.
Still
Lake.
down.
Mhm. She had a lot of questions.
I let her know that you don't got no case in the
Yeah, it's
She
like,
said she had a bond on a new case she got.
she just can't make it.
And no, it was this, I guess the probation revocation was holding up, but it ran out.
So what had happened, whoever her attorney is on the new case had emailed me and was like, can you get this resolved? And so that's when I emailed everybody. And then probation was like, she doesn't have probation. So then the hold came off. But for some reason it was like still, yeah.
$100 out there. Oh, so she was brought over for the whole.
Well, no, because I sent an email and it's like she's removed the calendar. It's like there's no like in honesty, there's an order that says like she's done. It was reduced to a misdemeanor. So she's like been done in this case.
Oh, I would be mad too, because she down there, she tripping on that.
Yeah, I don't blame her.
Who we turned to go to the verdict?
Really?
This was silly. Who you thought to go to the verdict?
Now you get a burn.
What's his name?
You said Brown name. But I think Brown number 7,
Huh?
1 and 17.
Yeah. I haven't seen Brown like.
Me? Oh.
Oh, that's what's his name? Look out.
Right.
I mean, well, he ain't no good.
Yeah, you work with him?
At the jail?
Yeah. How was he?
It was all right. I ain't work on the floor, but I remember him. He was trying to get me some point in time, but, and then he left.
Oh, so he was all night or he was on morning?
I think that's it.
No, I'm saying you.
What?
He was at the jail.
I do.
Huh?
I did night.
You was on last with me, when I first started. Yeah.
When I came back.
Why did you do that?
Sergeant, Cochran sent me back because I didn't want to be in background. They were gonna bring me back.
Yeah, but I do remember you in background.
She was there and told people something.
Why you like it?
Her like, she talk, she know I talk to you.
You like every person that.
She talked to you, she talked to you like through her child. Come see me. What?
I heard that. She might be this.
She quit. She was horrible.
I heard, yeah, somebody else quit.
And he was like.
It was like that too at that time.
I know, I'm like,
No, it ain't. Wait a minute. Nah. Yes, no. Don't know who's on.
it's an only.
I can't see it. I have no camera.
I did mention my overtime strike.
Is the letter? But then, I'm at the desk. Yes, sir. No, it's not.
Oh, it was not told me today.
Today? Yes. We want to,
Y'all want the next shot?
take it all out, what? Did you tell it?
No, I ain't gonna say. So I do.
Yeah, well, I still win. Before anybody.
I don't know.
So they take the dude and get off.
Thanks. Today.
So 760.
Yeah. I'm gonna get it. I'm gonna eat this myself.
We gonna sit down. We'll sit down. You watch my show.
Because
Oh my goodness.
Is Frazier gonna be your case?
I think that will actually be Lee's case, because it's, yeah, that'll be hers. Do you want me to
You
respond?
guys take, that's fine, you don't have to.
Okay.
What numbers do you have? Are you still?
So I have 0 through 4, and then she's got 5 through 9. There's some, but it's good that you asked, because there's some that I am taking to try to like even it out, since she's got most of the murders and rapes.
Okay.
But that one will most likely be hers.
Okay.
Yes.
All right.
Thank you for asking them.
No problem.
Hi. Are you covering for Travis this afternoon? Or is he coming back on the Zoom? Do you know?
You didn't ask me, but I guess I could.
Okay, I was just wondering because my client with him now wants to plea. It's negotiated. So I didn't know if he was gonna actually be back on the Zoom or not, but it's not a big deal.
Ask him. I don't know. I can ask him.
Yeah, no, I sent him an email. It's not a big deal. I just want to be like in and out.
Let's see. Check my other phone. I know he said he would come back.
Okay, yeah, no, that's totally fine.
And then text me. Let me see. Anything he texted us asking if Barnswell was my case.
Who was your case?
Huh? He's asking if Barnswell, Demarco was mine.
Oh.
Yeah, it is.
Oh, he just said he'll be back. Okay.
Okay. Is that the one who's also got something going on in DeKalb County? Mm,
That's
remember
her,
that email.
yeah. Oh, yeah, I didn't know he lived in that. He was my supervisor when I was an intern in DeKalb.
Oh my God.
It's like a full circle moment for me. He's like, he's in private practice now, so.
When I saw this, she probably saw the to the airport. I was like, oh yeah, let me. 900.
Of what?
While on probation, possession. She had a possession.
Oh, and that's what, I guess Harrelson County revoked her.
They revoked it, so now she's in October of this year. Okay. So while she was, she got this. Okay. That's a lot. I've seen like 47.
Yeah.
50-ish.
Oh my gosh. Yeah. Oh my goodness.
Did you tell her? Yeah, he said, I don't know if I anything. Okay, good, I can do it. Anything else? How much? A lot. So I was like, you're right, it's a lot. And I was like, how much is a lot? Yeah.
Oh my goodness.
Just sitting in the front seat.
No way.
Yes, I'm like, goodness. She's so young. And she knew.
She looks young, yeah.
She's like, I'm missing a photo. She looks good, you know.
Yeah.
Yeah.
Oh.
She just looks so young to be mom. So I don't know.
I know she does.
She is. I was looking at the 17 guideline, just gonna get a
Yeah.
sense of what that would look like.
Yeah.
And $1 million fight. I'm like, right, that's what I see him. How am I gonna say I have a straight face?
Right. No, but for real.
Is
Is that the minimum? That's the minimum
For
fine?
that amount, yeah. Oh my gosh, it's $1 million.
That's, oh my gosh, mind blowing.
It is, because it's over 400 grand.
You're gonna play.
Okay.
Mhm.
It's over 400 grand.
Wow.
Shit.
That's insane.
So like, we gonna talk. We have to- That's literally picking up.
Oh my gosh.
That's what
And no co-defendant?
She was the passenger. So
Ah,
the driver wasn't charged, because it was in the passenger seat in between the backs. So you can see the black bag when you bought it, and then she's like, that. And I know the passenger was livid. Why are you cutting them all this? Because they're just a person, hey, what you do? They were like park in the back. I was like, please stop doing.
oh my
I
goodness.
couldn't remember the blood.
Oh my god.
So officers were like, hey, you know, sitting there for a minute.
Right.
So like, everything okay, just wanna make sure you're good. And she's like, he's like, where you from? I said, Carrollton, huh, you know?
Oh no. Then it's all just downhill from
It's just like,
there.
he's like, you got my ID on you? I don't have my ID. He's like, oh, okay. He's like, wait, you got some water tickets in there? You know, he just like shit right there, just trying to see what's gonna go. He's like, I saw your hands move real quick when I was coming. What happened? And then she goes, I had a book. I was like, all right.
Oh my god.
Are you guys taking a plea or home?
Yes, yes, we are. Yes.
What about senior?
I think
No,
that.
he waived arraignment on that.
Yes, he's gone.
You have to.
So that was a female, oh.
Yeah, the attorney,
Okay.
yes.
Anybody else?
Barnswell will be a plea.
Okay. This all gonna be pretty good.
I know. It's about time we got her over here.
Yes, so 2 please, maybe Karen. 2 please. It's not bad. I mean, you wish it was more. Yeah.
Yesterday, could have accepted.
Oh.
So anybody has some stuff in that room, so I have to consign it everything. Sweep it. One case has 60.
What?
Huh?
Like, what do they count? Like just random
By
stuff?
taking this, I need it. This first one has 9 that you take. It's been for 100 plus.
Oh my gosh.
How did I start taking a plea? How do you put this?
Oh my gosh, it's gonna take forever.
Especially set this one.
Right.
I can't do this now, consolidate it.
Oh
It's
my
gonna be-
gosh. Oh, so I don't know if have you looked at the calendars for like next week and the first week of June?
Barely, I glanced at it, I haven't deep dive.
There's a ton of stuff. I haven't even, I'm just gonna have to like send you an email.
I saw some like Kevin Hansen.
There's a lot coming up and it's like, I feel like it's like all of my cases.
So I just in case if we're gonna ask some please.
So I'm gonna have to send you an email because I think that there's one on there for next week, Edward Cherry.
He has a bunch of them.
He has like 4 cases. So. That's right.
And you have to transfer some cases to me.
And I think that might be part of the problem, at least some of like Discover might have gone to like a different attorney in that courtroom. I'll send you an email, but just letting you know it's coming. It's coming, winter is coming. Hi, welcome back. Thank you. Where'd you go?
We just passed that. Take the next call.
Oh, okay. Was it busy?
Yeah, it was.
There's lots of traffic. Yeah. Oh, but it's so different from the square.
You know, when we see the Decatur Square.
Yeah.
Decatur Square is extra in some way.
There used to be, so yeah, there used to be downstairs, they had a cafeteria and we had like different menus. Like I know there was one day when they had Chick-fil-A come in, I can't remember what else, but then of course COVID. And then there was like food trucks. Like everyone was just so weird because of COVID. Like I don't know if they can do that anymore. Have you, I don't know if you've like been looking at any restaurants around office. Have you been like out exploring?
Not really. Yes, I've done a Highland Bakery, we call it Rose Mondays. And
Okay.
Brandon's and that's it.
Okay, yeah, there's like some other stuff, I don't know, there's different places.
Although that we do it.
Dwayne loves, I can't remember, there's like Mediterranean place that he loves. So yeah, I don't know. Everything's changed though, because there was way more before the pandemic. They should have just ended up bringing them. So. Yeah, that's what I was like trying, because we just moved, so I'm like, not just moved, but I have a different place, because I moved out of the county, and so I'm like very nervous to like find my spot, and so I like, because I like, I don't want to listen, I mean, I just like, don't know where I'm even going, because we live in Cobb County now, so I like know nothing about anywhere outside of like where I live. So. Very easy. So I haven't married as a code, but it's technically unincorporated code. Are you familiar with code? Not really, I know there's East. Yeah. So I'm not there. But I am like familiar with that area. So yeah, I would say really not super far from here. It's very interesting though, because we live like sort of like doesn't really like have an identity, but it's like in between a lot of stuff. So yeah. So yeah, but it's weird because there's one place that is literally like down the road from where we live, but it's not the one I have to go to. It's like lower my mind. So I gotta figure out where mine is. Oh, yeah. Have you met Jesus? Okay. Is it Torre? Okay. Yeah, so Jackie should. She's great. Just some reminders. Yeah, she should be able to. And if you need her to, she's like always willing to either come to court or hop on a Zoom, which is nice. To give more background about the programs and stuff. If needed. That's awesome.
This morning, gives his teacher.
Closer off to like the school.
She had to go down very close.
Okay.
But she had to go to her own
Oh, no. Right. Always. So she's doing.
She usually sit, then I take them, but then so I thought I felt it later, but I think it was just.
Oh, cool. I love that. So cute. Oh my goodness. That's like a chair. I love it. I definitely tried it. Oh, it's delicious. It's amazing.
Right, no. Friday. 9:30. Let me confirm for me. Save, okay. Before we bring are we ready for Mr. Barnswell?
Yeah.
Before we bring him out, what happened, if anything, with Ms. Hall?
It'll be a plea, Judge.
Happy, happy, joy, joy. We'll start with Mr. Barnswell. Please.
So he will give you the option. If you feel more comfortable doing it here, you can do it here. We'll just turn the mic back on, or you can go to the podium.
You can be wherever you want as long as you can be seen and heard by Ms. Rivers. Sometimes she's here, sometimes she's virtual, but that's the only tether you have is Ms. Rivers' ability to hear you. I don't get hung up on, are you standing? Are you at the podium? You probably want to be with your client. And so you're going to have some clients for whom sitting is such a better idea. And we'll do it that way. But others being at the podium is fine. And Ms. Charles typically takes the witness perch because she can be near that microphone. She's shy of the microphone. She stays away from them. So.
Yeah, that's pretty much.
Would you rather be here or would you rather be at the podium?
Let's see here.
You're okay here?
So just speak loudly and clearly into the mic when they
Yes,
ask
ma'am.
you questions, okay?
All right, Ms. Rivers, are you ready? Okay, this is position 1 from our inquiry calendar. It's State versus Demarco Barnswell. Good afternoon, Mr. Barnswell.
Good afternoon, Your Honor.
Mr. Barnswell, your case number is 21 SC 178146, and you are represented by Ms. Feely, who's seated next to you. Ms. Charles is the prosecutor. She's up here at the witness stand. And Ms. Feely tells me that you are prepared to enter a plea in your case. Is that correct?
Yes, Your Honor.
And I think we may be addressing an unindicted case you have as well. You won't be entering a plea to that, but that case may be moving along in conjunction with the case we're going to work through today. For you to enter a plea, you need to be put under oath. Ms. Charles will do that in just a moment. Once you're under oath, it's important that you answer all of her questions and mine truthfully and completely. It is just as important that you let Ms. Feely or me know if you've got questions of your own. If something comes up that you don't understand, or Ms. Barnswell, Ms. Feely told you, hey, it's going to go this way, and it starts to go that way, then we should stop so the two of you can talk about why it's going differently than you expected. Will you do that?
Yes, Your Honor.
Great. Ms. Charles, when you are ready.
Thank you, Your Honor. Your Honor, this plea, as you just correctly stated, will be taken into consideration both of Mr. Barnswell's cases, the indicted case 21 SC 178146, along with 22 CP 206589. And it will be a negotiated resolution of a plea into the Behavioral Health Treatment Court.
And has Mr. Barnswell already been accepted?
Accepted, and we have the agreement signed. We're just going to go ahead and take the plea.
Okay. The 22 CP case, what are the charges? And I'm assuming you're not going to go into the facts of that because you don't need to. I'm just curious. I can look it up. If you don't have it at your fingertips, I'll look it up while you're covering other things.
Okay.
All right.
Your Honor, it was an aggravated assault on a law enforcement officer, obstruction.
The 22 CP.
Yes.
Okay.
That's interference with government property, simple battery. So it's 2 counts of simple battery, obstruction of a law enforcement officer, and criminal damage to first degree.
Okay. Thank you.
Mr. Barnswell, can you see me?
Yes, ma'am.
Can you please raise your right hand?
Yes, ma'am.
Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You may lower your hand. Can you please state your true, correct, and legal name?
Demarco Barnswell.
Can you spell that for the record, please?
It's DAMARCO DARNELLBARNSWELL.
Thank you. Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
How old are you and how far have you gone in school?
I'm 32 years of age and I completed 11th grade.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you're being charged with the following offenses today? Aggravated assault, simple battery family violence, and battery, misdemeanor battery, family violence.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am, I understand. Yes, ma'am.
Yes?
He said he understands.
Thank you. Have you reviewed the waiver of rights with your attorney?
Yes, ma'am.
Have you had enough time to speak with your lawyer, Ms. Feely, about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Are you satisfied with her services?
Yes, ma'am.
Do you need more time to discuss the case with your attorney?
No, ma'am.
Do you waive formal reading of the indictment, Ms. Feely?
We do, thank you.
Do you waive any and all defects in the indictment, Ms. Feely?
Yes.
Mr. Barnswell, have you been arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Do you, Mr. Barnswell, or your attorney, Ms. Feely, know of any outstanding warrants that are related to these charges?
No, ma'am.
No.
Has your attorney advised you of the minimum and maximum sentence for each charge you're pleading to today?
Yes, ma'am.
In the case of aggravated assault, the maximum would be 20 years, minimum 1 year. In the case of simple battery, misdemeanor, family violence, the maximum will be 12 months. And similarly for battery, misdemeanor, family violence, 12 months.
Yes, ma'am.
Do you understand, Mr. Barnswell, that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 10 years to serve 2, reduced to time served, the balance probated with special condition of successful completion of behavioral health treatment court.
Yes, ma'am.
Mr. Barnswell has been in custody 101 days to date, Your Honor.
Okay.
But Mr. Barnswell, the court does not have to accept this recommendation. The court can sentence you to the maximum on each charge and can run those sentences consecutively, which means one after the other.
Yes, ma'am.
Do you understand that this plea may be used to enhance sentencing and other convictions in this jurisdiction, as well as in other jurisdictions, including the federal courts?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special condition of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that you are not allowed to use or possess a firearm while on probation?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that you are pleading guilty to a felony and therefore you may not receive, possess, or transport a firearm? And if you do, you will be guilty of a felony which may carry a sentence of 1 to 15 years.
Yes, ma'am, I understand.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that if you had went to trial, you would have had the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, ma'am.
How do you plead to the charges of aggravated assault, simple battery, and battery in indictment 21 SC 178146?
Guilty, ma'am.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you only have a limited right to appeal this guilty plea conviction? You have 4 years from today to appeal a felony charge and 12 months from today for the misdemeanor charges to file a habeas corpus petition challenging the voluntariness of your guilty plea.
Yes, ma'am.
Your Honor, the state is aware of 6 prior felony convictions for Mr. Barnswell dating to 2012, the most recent being 2017 in Fulton County for willful interference of medical staff.
That was the 2017?
Most recent.
Okay.
And prior to that was 2015 in Clayton County for terroristic threats. In 2014 in DeKalb County for stalking. In 2011, DeKalb County, terroristic threats. And in 2012, Fulton County, obstruction of a law enforcement officer. You're going to have this case gone to trial. The state would have expected to show that on February 15th, 2021, at approximately 3:29 p.m., officers will dispatch to 916 Redford, REDFORD Drive, Southwest in Atlanta. On their arrival, they met with a victim who was identified as Ms. Tapita, Taptita Ford, F-O-R-D, who was a roommate living in the same house, which belonged to Mr. Barnswell's mother and Mr. Barnswell. Ms. Ford stated she had been at home relaxing when Mr. Barnswell entered the bedroom and started to throw around some of his belongings. There was a confrontation. Mr. Barnswell got upset and threw a punch, hitting Ms. Ford in the face. Afterwards, he picked up a razor blade, threw her to the ground, and threatened to keep beating on her, and also attempted to throw around a television. Mr. Barnswell's mother tried to break up the altercation, and she also was punched by Mr. Barnswell. Ms. Ford then called 911. Mr. Barnswell left the scene of the incident. When officers arrived, Ms. Barnswell informed officers that her son suffered from schizophrenia, postpartum disorder, and autism. Mr. Barnswell was subsequently arrested and charged accordingly. In the 22 CP case, on the 21 SC case, he received a $10,000 bond and he was released on bond. While he was on bond, he incurred a 22 CP case on February 12, 2022. There was a family gathering again at 916 Redford Drive, and officers responded to a call of a demented person. There, Mr. Barnswell again was agitated and angry and accosted other family members, including one of his aunts, Ms. Jones. No one was treated for any medical injury. However, once officers arrived on scene, Mr. Barnswell barricaded himself in the property, holding what was described as a large wood, almost like a 2x4, and threatening to self-harm and threatening to kill himself. The officers was to enter into the home. Officers were ultimately able to push their way in, and they were able to bring Mr. Barnswell into compliance, who was visibly having a full mental breakdown, and he was transported to Grady, where he had to be sedated and ultimately treated. During the course of being transported to Grady, Mr. Barnswell was kicking the officer's vehicle in the back of the patrol car, kicking the windows, kicking the seats, and attempted at one point to lunge or punch at one of the officers. And he was, once he was released from Grady, he was taken into custody and charged accordingly. And so in talking to myself, prior to Ms. Feely's arrival, Ms. Patel, talking to her, we understood that there is some mental difficulties with Mr. Barnswell. He needs some treatment. He doesn't take his medication as he should, and that's why we thought BHTC would be the appropriate sentence for him to get that care and supervision that he needed and hopefully be on the right track.
Okay.
Thank you. That's it, Your Honor, so we have staff at you.
Ms. Tucson, is Mr. Barnswell on any active probation now?
No, Judge. His probation ended in 2020, April 20th, 2020. So he's not on probation at the moment.
Okay. And Ms. Jackson, do you have any other information? I heard from Ms. Charles about 4 or 5 convictions running from sort of 2012-ish to 2017.
Nothing in addition, Your Honor.
Okay, thank you. Ms. Feely, I've got a few questions for you and for Mr. Barnswell, but why don't you start by sharing with me what you want to about Mr. Barnswell?
Thank you, Your Honor. As the court heard, he's 32 years old. He went through the 11th grade. He has a 7-month-old daughter and a fiance as well, waiting for him on the outside. He's done fast food work, most recently at Zesto. And I have a letter here that I've shown the state from his case manager, who I have been in close contact with and believes that based on Mr. Barnswell's compliance with him and with ICM, that he is ready and in a good place to be compliant with the treatment court.
Case manager means someone at the jail, or case manager means someone like from a Grady Act team?
It's Grady Intensive Case Management. Yes,
Okay,
Your Honor.
got it.
He's been med compliant, and Mr. Howard has visited him, looked like almost weekly for quite some time now. And Mr. Barnswell, of course, has been very cooperative and willing to listen to my advice. And I believe he is, most of his cases, as the court can probably tell, do kind of stem from his struggles with mental health. So we're just asking the court to accept this.
The fiance, is she one of the alleged victims in the unindicted case? There were some Joneses and Barnswells who were all at the house. Some of them got bleach thrown on them, things like that. Are any of them the fiance?
Anita Jones, but we working it out on good terms and everything. And
Okay, but she was there that night you got arrested.
yes, sir.
Okay, and that wouldn't have been 7 months ago. It's less than that. So was your baby daughter there at that time too?
Yes, sir. To be honest, but my sister had took her for the day, that day.
Okay. Taking her as in you resisted, or your sister was taking care of your daughter?
Sister had babysitted her that day.
Okay, got it. So, Mr. Barnswell, one of the questions Ms. Charles asked you is whether you're under the influence of any drugs, alcohol, or medication at this time, and you said no. I'm going to ask it a little bit differently. Are you regularly taking medication through the doctors you see at the jail?
Yes, sir. I take Depakote 1,000 milligrams and Lexapro 10 milligrams in the morning, and Depakote 1,000 milligrams at night, sir. Excuse me.
So Depakote and Lexapro?
Yes, sir.
How long have you been taking those?
About close to a year now. Actually.
Okay. So both before you got locked up and after you've been taking those?
Yes, sir.
When you take the Depakote and the Lexapro, do either of those make you woozy or drowsy or unable to understand what's happening?
The Depakote at night makes me woozy, and the Lexapro kind of mellowed me out during the day.
Okay. And you did not take Depakote just before coming over to court?
No, sir.
You took the Lexapro?
Yes, sir.
Okay. Do you feel that either of those medications right now is making it hard for you to understand what we're talking about?
No, sir.
Where will you live when you're released?
Well, Mr. Howard talked to my sister. She said it's cool if it's okay with the court. It's cool. Can I go back with my fiance?
Is that at the address that I've got? Is this Redford Drive? Is it going back there or to a different place?
To Redford Drive, actually.
Okay. That's where you were required to stay under the conditions of your bond in this case.
Yes, sir.
Unfortunately, that's where this situation in your newer case occurred. But that's your sister's house?
Yes, sir.
Okay, and she's saying it is okay for you to go back there?
Yes, sir.
All right, and that's where your fiance is staying?
Yes, sir.
Is it a big house?
Pardon? It's just it's a 2-bedroom house with office space, actually.
Okay, so there's room for you, your daughter, and your fiance?
Sir.
Tell me what you know about the behavioral health treatment court.
Well, I know I'll be drug tested numerous times a week, and I have to attend classes in the morning from 12 until 12:30, sir. And I had to abide by curfew and check in with them, do drug testing.
Are those things you think you can do?
Yes, sir.
I don't know where Redford Drive is, but I do know where Hope Hall is. That's where when you're going in for the drug tests and for some of the meetings, that's over, it's right by where you live right now. It's right near the jail. How far is Redford Drive from the jail?
It's not that far, about 15, 20 minutes.
How will you get from your sister's place to Hope Hall?
I've used public transit. more.
Okay, bus or train?
Yes, sir.
There's something near your house, and I know there's something near Hope Hall. So that's how you'll be getting back and forth?
It's in Southeast Atlanta. I catch can catch 3 bus routes, actually. I got a bus that come by my house, and I got 2 I catch once I walk up the street from my house. So.
Okay. Got it. Ms. Feely, did you have anything else on behalf of Mr. Barnswell?
Nothing further at this time, Your Honor.
I need you to tell me your first name. You're Ms. Feely to me formally, but I am, and I'll cover this in a minute. I'm electronically signing the indictment, and I have Ms. Charles's name. I got Mr. Barnswell's name. I don't have yours.
So my first name is Lee, L-E-E.
Oh, that'll be easy to remember. Lee Feely. It's all built in. Lee Feely. Did you end up filling out the waiver of rights form or plea form, whatever it's called?
We went over it. I did not have him initial, but I did read him.
Okay. And you felt he understood the contents?
Yes, Your Honor.
Okay. Do you have any questions, Mr. Barnswell, about anything that we talked about?
No, sir. So I have a question. Hope Hall is it's on Jefferson Street, to be correct, right?
On which street?
Jefferson.
Yes, it's on Jefferson.
Yes, sir.
Yeah.
I just want to be correct.
Sure. It's a good question. And Ms. Charles, I don't know if you've spoken with any of Mr. Barnswell's family members. It sounds like he's going to be moving back in where this incident happened, involving many of the same family members.
They were just concerned about him getting treatment. They understood that he has some mental breaks, and that was just one of those. And they were happy to see that he gets some treatment and hopefully he's better.
All right. Well, Mr. Barnswell, I find there's a factual basis for your plea, meaning if this case went to trial and the jurors heard from Ms. Ford what happened and your mom what happened, they could find you guilty of what you're charged with in the indictment. I also find that your plea is knowing and voluntary. Voluntary means no one's forcing you to enter this plea. Do you agree with that?
Yes, sir.
And knowing means you've understood all the things we talked about, which I believe is true because I just asked you if you had any questions about anything and you said you were good. Is that still true?
Yes, sir.
Then I'm accepting your plea. I will sentence you on count 1 in this case to a term of 10 years to serve 2 years. Those 2 years will be reduced to the time you served. The balance will be on probation. So that's 8 years probation. Counts 2 and 3 will both be 12 months to serve. They'll run concurrently with count 1, and they will be reduced to time served as well. You're being sentenced pursuant to the Probation Options Management Act. And all that means is that while you're on probation, if you have a minor violation, sometimes called a technical violation, you and probation can work through that. But if it is more serious, you get arrested again, or you get terminated from BHTC, a judge is going to hear about that and figure out what ought to happen next. It will be a special condition of your probation that you complete the behavioral health treatment court. So if you are terminated, that's a violation of probation. You'll probably be taken into custody, and then you and a lawyer working on your behalf will figure out what else can we try for Mr. Barnswell. I'm hopeful that you'll take the program seriously and that it will help you chart a more stable course, which sounds like involves you staying on your medication and maybe meeting with doctors pretty regularly because right now we're having a very calm and I think informative in both directions interaction. It looks like there are times when there's a very different Mr. Barnswell, and maybe you hadn't been taking the medication, and then the parts of you that the medication helps you manage take charge. And then that gets dangerous for you. It gets dangerous for the people you care about. I know you wouldn't ever want something to happen to your daughter because you got off medication and you thought your daughter was threatening to kill you, and so you throw her against the wall. That's a bad outcome for her in particular, but it would mean you're going away for a long time. And so the care and treatment you'll be getting through BHTC, through Grady, if they're still supporting you, which I hope they will, that is done to help you keep heading in a safe and healthy direction. Ms. Charles, were there other conditions you wanted for probation? There's no stay away because you're agreeing that it's okay for Mr. Barnswell effectively to go back home, to be around the people who were the victims in his case.
I just want to add perhaps, periodic drug testing and also any further treatment recommended by probation would have to follow as well.
So as Mr. Barnswell noted, he'll be getting all sorts of drug testing while he's at BHTC. If he successfully completes that, there is an aftercare regimen that probation will apply. So we would revisit what to do only if Mr. Barnswell is terminated from BHTC. So I'm going to leave it at that. Ms. Feely, anything else on behalf of Mr. Barnswell?
No, Your Honor, thank you.
Mr. Barnswell, normally we would hand, or back in the day, we would hand the indictment around. You'd sign it, saying this is my guilty plea. Ms. Feely would sign as your lawyer, et cetera. But we're trying to do that electronically now, just so less paper moves around. Do you authorize me to sign your indictment?
Yes, Your Honor.
Ms. Feely?
Yes, Your Honor.
And Ms. Charles? Great. And I think we're done. Mr. Barnswell, you should be released soon. The way this is going to work, ideally, is that I didn't want to get this wording correct. I don't want Mr. Barnswell released until he's starting BHTC. And I can get an order from BHTC that says Mr. Barnswell is to be released to BHTC personnel only. I don't know. I know drug court every Wednesday they do orientation. And so they'd be able to grab Mr. Barnswell tomorrow or the following Wednesday. I don't know if BHTC is part of that orientation or if it's a different day of the week. But what I'm going to do, Ms. Feely, is task you to figure out when that would be and then to work with BHTC. It's fine if the release order comes from you. It typically comes through the admin at the accountability court, but I only see the drug court ones. I don't see BHTC. Does that make sense?
Yes, Your Honor.
Okay, so Mr. Barnswell, just because one of your questions might be, when do I get out? The answer is real soon. It'll be in the next few days, but I want you to be released to the behavioral health folks so they can take you straight to Hope Hall for that initial orientation. You'll go home that night, you'll go home that afternoon and be back at Redford and doing your thing. But I don't want there to be a gap where maybe then you don't plug in and then it gets more complicated. You may also be given an ankle monitor. I don't know how they're doing it on BHTC, but in drug court, everyone who starts for 30 days has an ankle monitor. You don't have to pay for it, but it's just a way for us to make sure during those initial days, we don't lose track of anyone. So don't get alarmed if you are given an ankle monitor at orientation for BHTC. It's only 30 days. Everyone gets one, I think. I know in drug court, everyone gets one. And that's just to make sure you're staying where you say you're staying and everyone develops a comfort level that Mr. Barnswell's doing okay. All right. So you'll get out soon. I'm going to hold off on signing your final disposition. I may need to reword the sentence that it's 10 years to serve to reduce the time served upon entry into, and then the jail holds on to Mr. Barnswell until we get that release order. Okay? Thank you, everyone.
Will I be able to get the address, I guess from the public defender?
Sure, I can give it to you right now. It's 916 Redford, as in Robert Redford Drive, Southeast. It's Atlanta 30315.
Is this to Hope Hall or to his residence?
That's the address for his resident. That's where he'll be living. Hope Hall's on Jefferson somewhere. You can look it up. But that's not going to be his home.
He needs to report to probation after he's released.
I don't think so. If you were going into any of the accountability courts, Officer Malud is the DCS officer detailed to the accountability courts, but our folks don't typically
They'll coordinate with her. And then, okay, I'll let her know that as well. So,
excellent.
Thank you.
Thank you. All right, we're gonna do Ms. Hall?
Yes, Judge.
Great.
Judge McBurney, Scott Fortis here. How are you?
Well, how are you, sir?
Good. I think I might be on your 1:30 calendar. Are you just taking quick announcements or no?
Nope, we're taking this one plea and then we will figure out what's going on with the cases on the status hearing calendar. So one plea and then we'll take attendance.
Okay, great. Thanks, Judge.
You bet.
Stand right here and then speak loudly and clearly into the mic when they ask you questions, okay?
Hello, Ms. Hall.
Hello.
How are you?
I'm fine, and you?
I'm hanging in there. Ms. Hall, you are position 3 on our plea and arraignment calendar from this morning. We have borrowed you from somewhere in the state system, and I'll hear about that from Ms. Wood in a little bit. But Ms. Wood tells me that you are prepared to enter a plea in your case. Is that correct?
Yes, sir.
Okay. I am going to make the prosecutor real big on your screen there. That's Mr. Thomas. He's the prosecutor on your case. And in a moment, he's going to put you under oath. Once you're under oath, you'll need to answer his questions and mine truthfully and completely. But I want to be sure that Ms. Wood or I answer any questions you have. So if we get partway through and something happens, like, what are you talking about? Raise your hand or nudge Ms. Wood. It's important that I'm comfortable that you understand everything we're talking about.
Yes,
there aren't
sir.
meant to be any surprises, but sometimes something goes a little differently than you were expecting. Will you let Ms. Wood or me know?
Yes, sir, I will.
Excellent. Mr. Thomas, when you're ready.
All right, thank you, sir. Good afternoon, Ms. Hall.
Good morning. Well, good afternoon.
It's afternoon, 1:30.
Oh, well, good afternoon.
Yeah, time flies when you're back there.
So we are taking this over. I'm appearing via Zoom. If I go too fast or for some reason you can't hear me, just ask that I repeat the question, okay?
Yes, sir.
All right, please raise your right hand. Do you swear or affirm that the testimony you shall give in this matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You may lower your right hand. Please state your true, correct, and legal name.
Tila LaShawn Hall.
And are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, sir.
Is there any medication that you normally take that you have not been given today?
No, sir.
How old are you and how far have you gone to school?
I'm 35 and I have a GED.
Are you able to read, write, and understand the English language?
Yes, sir.
Do you understand that you are being charged with the following offense: aggravated assault, family violence?
Yes, sir.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, sir.
Have you had enough time to speak with your lawyer, Ms. Woods, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
I have.
Do you need more time to discuss this case with your attorney?
No, sir.
Are you satisfied with her services?
I am.
Ms. Woods, do you waive formal reading of the indictment?
So waived.
And do you waive any and all defects in the indictment?
So waived for purposes of this hearing.
All right, Ms. Hall, have you been arrested on these charges?
Yes.
The state is unaware of any outstanding warrants related to these charges. Do you or your attorney know of any outstanding warrants that are related to these charges?
No, sir.
No, sir.
Has your attorney advised you of the minimum and maximum sentence for each charge you're pleading to today?
Yes, sir.
For aggravated assault family violence, the minimum is 3 years and maximum is 20 years. Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 4 years to serve 1 year, which will run concurrent to your DeKalb County revocation. No contact with the victim, stay away from the incident area, and you must complete the family violence intervention program.
I understand that, except to stay away from the victim part.
We'll address that, Judge.
Okay. And so we're clear, we're talking about Mr. Moon.
Yes.
Okay, we'll talk about stay away, no stay away, when we get there. The key part, 4 years to serve 1 concurrent with the DeKalb revocation. That's not news to you.
No, sir.
Okay, all right.
All right. Okay. But do you understand that the court does not have to accept this recommendation? The court can sentence you to the maximum on each charge. You can run those sentences consecutively or one after the other.
Yes, sir.
Do you understand that this plea may be used to enhance sentencing on other convictions, or other convictions in this jurisdiction, as well as in other jurisdictions, regardless or including in federal courts?
Yes, sir.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes, sir.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to the revocation for the balance of the sentence?
Yes, sir.
You understand that you are not allowed to possess or use a firearm while on probation?
Yes, sir.
Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would, and that is true regardless of any advice your attorney or anyone else has given you?
Yes, sir.
Do you understand that there may be other adverse or unfavorable consequences as a result of your guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, your right to receive, possess, or transport a firearm, or your ability to obtain employment.
Yes, sir.
Do you understand that by pleading guilty to a felony, if you use, receive, or possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes, sir.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a guilty plea?
Yes, sir.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes, sir.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal if convicted of these charges after trial.
Yes, sir.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, sir.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, sir.
How do you plead to the charge in indictment number 22 SC 180273?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes, sir.
Do you understand that you may have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes, sir.
So, Your Honor, if this case would have went to trial, the state would have proven beyond a reasonable doubt that on July 29th, 2021, the City of Atlanta police officers responded to 1084 Faith Avenue Southeast, which is here in Fulton County, to a domestic dispute with a person armed with a knife. Mr. Antoine Demetrius Moon, and I'll spell that first name, Antoine, last name Moon, advised police that his ex-girlfriend, Miss Tila Hall, came to his house and they argued about him taking her and her mother off of his cell phone plan. He said Miss Hall stabbed him when he tried to grab the knife to keep her from cutting him. Mr. Moon sustained cuts to 3 of his fingers on his right hand. Miss Hall also bit Mr. Boone on his left arm. He was treated on the scene by Grady and advised that he would follow up with his own doctor for a tetanus shot on the next morning at his scheduled appointment. Mr. Moon was able to identify Miss Hall from a photo, and she was later arrested on these charges. Your Honor, I do not have specifics. I wasn't able to pull a GCIC.
I'll get that from, we've got 2 experts on the line to cover that.
Yes, Your Honor. So after talking with Ms. Kyles and talking with the victim and looking at the history, I do believe this is a fair resolution to this case. I would ask that you accept this plea.
Do you know what the DeKalb case was about? Someone here does, so we'll get to that. I'm just curious if you know
Yes.
what kind of charges Ms. Hall is serving a revocation on.
Yes, sir. So I wasn't able to pull the DeKalb case, but I know she does have aggravated assault charges out of DeKalb. This could be the case, but I wasn't sure because I wasn't able to pull the revocation.
Okay. All right. Well, let me start with Ms. Tucson. Ms. Tucson, what is the probation that Ms. Hall is on now?
It's DeKalb County 12 CR 2103-6 for aggravated assault, ends May 28th, 2026. So it's 4 years and 4 days left on that case.
Okay, and that's what got revoked sometime recently?
Yes.
How much got revoked?
It looks like, one second, I'm gonna pull that. Right now, it says two years.
Okay, and does it say, whatever it is, why there was a revocation?
Let me see. There, because ours are a little bit different. Just give me one moment and I'm gonna pull that back up on here because I had spoke with it about it with Miss Wood earlier.
While you're looking for that, let me check with Ms. Jackson. Ms. Jackson, do you have other criminal history for Ms. Hall?
Yes, Your Honor, she does have prior felony convictions and a sentence. There was one in 2006 out of Cobb County for Terroristic Threats Act. And she received first offender treatment in 2004 for 3 counts of financial transaction card theft and theft by receiving stolen property. and the defendant does have misdemeanor sentences and convictions. The defendant received a nolo contendere sentence in 2009 out of DeKalb County for obstruction of an officer. And the defendant received a nolo contendere sentence in 2006 out of Cobb County for obstruction of an officer and giving false information to an officer and possession of marijuana less than an ounce. And there was one in 2004 out of Cobb County for giving false information to an officer and criminal trespassing. And there was an additional one in 2004 out of Rockdale County, Georgia, for reckless conduct. In addition to that, the defendant does appear to have a history of probation violations. There were 2 in 2021 and 1 in 2019. Nothing in addition, Your Honor.
Thank you. Ms. Tucson, did you find anything out about why
Yes.
did?
Yes, Judge, I do have the revocation order here. And the revocation order is dated on, it was filed March 3rd, 2022, and it was for aggravated assault on 7/29/21. That was what the,
It's this case. Got it. So Ms. Hall got revoked 2 years in DeKalb for these charges.
correct.
We're going to layer, not on top, but alongside it, this sentence. That's why revocations can help resolve cases, prosecutors. Okay. Thank you so much, both of you. Ms. Wood, what do you want to share about Ms. Hall?
Thank you, Judge. Just briefly, you may have noticed a little bit of hesitation when she asked about her desire to plead guilty. The reason that I think that is because she's actually back with Mr. Moon. They have ironed out their problems since that July day. That is also part of her issue with the stay away, because she's indicated to me that they are back together and in a relationship. And so if we could perhaps maybe structure something in there that allows for her to have contact with him, as long as he wants that contact, we would be appreciative. Judge, she is 35 years old. She's a lifelong resident of the Atlanta area. She has 4 children. She does have her GED. Prior to this arrest, she worked at Amazon. She is eager to get back down to Pulaski and finish out her sentence. She's enrolled in classes there. She also works in the kitchen, Judge. She's just indicated to me that she's ready to move forward. She has been in continuous custody since August 17th of last year. She was released from here on November 7th, straight to DeKalb, and then she was sent down the road. So we would just ask for all that credit. Otherwise, we'd ask that you would accept the state's recommendation. My final request would be that once she is released and instated to probation, that the court would consider waiving her probation fees until she's able to get back into a stable job.
All right, it was a lot. Ms. Hall, I've got a few questions. And then if there's anything you want to add, you're welcome to add things. 4 kids.
Yes, sir.
How old is the oldest?
My oldest is 19. I have a 15, a 13, and a 3-year-old.
3.
Yes, sir.
And with whom is the 3-year-old staying?
My 3-year-old is staying with her grandfather.
Is that a safe place for the 3-year-old?
Very much so, yes, sir.
Grandpa's a good guy?
He is very much retired veteran.
Okay. Maybe you should stay with him too. The 19-year-old is an adult, so he or she's doing that person's own thing.
Yeah, she's raising her own child.
Okay. Following in her mom's footsteps. The 15 and the 13, where are they staying?
The 15-year-old, she stays with where the 3-year-old is at her grandfather's house. And my 13-year-old is at her dad's house for the summertime.
And her dad is not Mr. Moon?
No, her father is Mr. King, which is the one who I initially caught the aggravated assault charges for.
The DeKalb case?
Yes.
Your DeKalb case, what happened to Mr. King?
I walked into my home and caught him in my home with another female in my bed.
Oh,
and
it didn't end well for Mr. King.
No, I stabbed both people in my home.
Okay. Got it. So you and Mr. King are not an item anymore.
No, we're not an item. You know, we co-parent very well, but that's about it.
Okay. What did you do for Amazon?
I deliver packages.
Will you be able to go back? Well, it's gonna be a while. Who
they
knows?
turned around and before I left, they had me on a medical leave because right before I got incarcerated, I got into a car accident and the humerus bone in my right arm got broken. So I was on medical leave when I left. I'm just hoping that I can actually go back to my job when I get out.
Got it. What kind of classes are you taking at Pulaski?
Right now I'm doing cosmetology classes and culinary arts.
Mr. Moon, you think it's safe for you to be around Mr. Moon?
We actually don't have any bad blood with each other. You know, this was just a really bad misunderstanding, really. He also stated and wrote out an affidavit letting the courts know that I honestly never stabbed him. You know, we did get into it. We tussled with each other because I was trying to leave and he didn't want me to go, you know, and in the process of that, you know, me and him end up falling. He scraped his knuckle and I did bite him. Like I told him, I did admit to bite him because I did. I bit him to get him off of me. When I got him off of me, I went out the door, I got in my car and I left.
Okay. I think more of the concern about this case is, gosh, look what happened to Mr. King and the unlucky lady with him. And then something like this happened. So whether there was a knife or this or the bite, I think the general concern is, heck, you're 35 now. You need to be able to deal with conflict in relationship without a knife or teeth or something like that. You got a 3-year-old who does not need to see something like that happening. Not that the 3-year-old watched this happen, but I think that would be my emphasis on how things might work for you when you get out. You're smart, maybe a little headstrong. You've worked, all that kind of stuff. And I need from Mr. Moon something in writing saying, I'm fine having Ms. Hall around. You've got a minute to have that happen because you're not going anywhere right away. I mean, you go back to Pulaski right away. But if Mr. Moon gets me something in writing, and that will work through Ms. Woods, you just work with Ms. Wood, I see it, excuse me, and the prosecutor sees it, then I'll modify your sentence. So your sentence is going to start out with no contact with Mr. Moon.
Okay.
Easy enough because you're going to be in state custody. But you'll get out. And if you and he still have a special something for each other.
Yeah, he's
then,
actually my fiance. So
pardon me?
He's actually my fiance.
Okay.
So.
And that's a title. And it may become more real when you get out. And that'll work if I get something from Mr. Moon saying, I love her and I want to be with her, or whatever his words are going to be.
Right.
You don't need to get all mushy with me because I'm not that way with Mr. Moon. But if he and you are going to be together, that's great. All right. Do you have any questions about anything we've been discussing?
No, sir.
Okay. Well, I find there's a factual basis for your plea. I hear you that maybe if the jury heard everything, they might not think that you pulled out a knife or something, but that there was a tussle. You were a part of that tussle.
Yes,
My
sir.
guess is the jury would hear about maybe what happened in DeKalb, and then they'd have a certain way of thinking about you, and that would make your trial complicated. So I understand why you're entering your plea. I also find that your plea is knowing and voluntary. Knowing means you've understood everything that we've been talking about. Any one of the folks, Mr. Thomas, Ms. Wood, or myself. Is that a true statement?
Yes, sir.
Voluntary means what you know it means. No one's forcing you to do this. You've decided on your own this is the right way forward, correct?
Yes, sir.
Great. I will accept your plea. I will sentence you pursuant to the Probation Options Management Act, which means only that while you are on probation, in this case, I don't know what your DeKalb sentence, how it was structured. If you have a technical violation, maybe you miss one of your family violence intervention classes, probation is going to fuss at you and they may say, hey, you got to go do community service or something. I'm making all that up, but you don't have to see me. You will see me only if you get arrested again, or you violate one of the special conditions, one of which will be no contact with Mr. Moon until I get proof from Mr. Moon that he doesn't want that condition.
Yes, sir.
All right. So I will follow the joint recommendation, sentence you to the only count of your indictment to 4 years to serve 1 year with a balance on probation. So it's basically a 3-year probation sentence because you're already doing that DeKalb revocation. The sentence that I just mentioned will run concurrently with your DeKalb case for which you're doing the revocation. And if someone has that case number, we'll put it in the actual final disposition. So no one has to guess which DeKalb case we're talking about.
I think I have it. Is Miss Tucson still on?
She should be, Miss Tucson. She's here. Do you have that DeKalb case number?
Sure. Let me know when you're ready.
Ready.
Ready. Okay, it is. It is 12CR2103-6.
That's what I have, Judge.
Okay. And then you mentioned that before, but that's like a 2012 case. So this situation with Mr. King, it was 10 years ago?
Happened in 2011.
Oh, so the 12 just must mean something different. I thought in DeKalb, the first two digits.
I got arrested December 5th, 2011.
So then it might have been indicted in.
Oh, so it happened a long time ago. Okay, but you recently dealt with it. Were you on the run?
No, I was never on the run.
Okay.
You know, behind it, I got arrested actually the exact same day that it happened. And I stayed arrested since then. I done 6 years. They gave me a 15 do 6. I done all 6 years and got out with 9 years left to do on paper.
Oh, now I'm getting it. Okay. So you've been out for a while. Wow. How badly did you stab these people?
Pretty bad.
Everyone's still alive?
Yes.
Because it's ag assault, not murder.
Yeah, everyone's still alive. Yes, sir.
Okay. Can Mr. King walk?
Yes.
Does he have all his parts?
He's very functional.
Okay. All right. Anyway, this sentence will run concurrently with that 12 CR case. For now, it'll be a special condition of your probation that you have no contact, direct or indirect, with Mr. Moon. You don't call him, you don't write him, you don't text him. You don't have any friends do that either. Hey, tell Antoine I miss him. Come visit me in Pulaski. If he gets any contact from you, that's a violation. Well, it will only be a violation of your probation. So once you're out.
Okay.
But I'll remove that if Mr. Moon asked me to do so.
Okay.
Another special condition of your probation will be that you complete a family violence intervention program course.
Okay.
There's not one class, but actually a series of classes.
Okay.
I have no idea. They may have something like that at Pulaski, and you'll get credit for it if you do it there. But if you don't, because you can't, because it's not there, when you get out, you'll need to enroll in that program. And there are bunches, there's not just one in Fulton County.
Okay.
Different places offer them, but it's a series of classes that will help you maybe process the inevitable conflict you have with those about whom you care in a way other than whatever happened in DeKalb in 2011.
Well, that's something I'll never do again.
Okay, good. I hope you never encounter something like that again either. And I will waive your probation supervision fees for the first 4 months of your probation. So you can get that job back or do something else and start earning before you also need to pay a little bit to probation. Mr. Thomas, anything else in Ms. Hall's case?
Nothing else from the state, Your Honor. Thank you.
Ms. Wood?
No, Your Honor.
Ms. Tucson, do we need to give reporting instructions to Ms. Hall, or because she's going back into state custody, she'll get that kind of info when she gets out?
That's correct. And she'll be on with DeKalb if she's still residing in DeKalb. So as long as she reports, this case will be uploaded into the system. So they will see that she will report, for this case as well. And as long as she lives in DeKalb County, she'll be supervised by DeKalb.
Right. Thank you. So you're going to have probation in both cases. You don't have to be reporting in both counties. You live where you live. If you and Mr. Moon are living together and it's in Clayton, you'll be reporting in Clayton. And these two cases will follow you along. But you do need to report when you get out, wherever home is, whatever county that is. But you'll get that information before you get released.
Yes, sir.
Any questions?
No, sir.
All right. That's it. Good luck.
Right, thank you.
Thank you, Judge. Good luck, Ms. Hall.
Family Violence Intervention, FVIP. Mr. Thomas, I appreciate all your limited energy today. Go lie down, get well, and we'll see you soon.
All right, thank you, Your Honor. You do have my permission to sign on any papers that need to be signed.
Oh, right. We didn't do that part. Hey, Ms. Hall, do you authorize me to sign the indictment for you saying that you entered a guilty plea?
Yes, sir.
And Ms. Wood?
Yes, Judge.
Thank you, Mr. Thomas.
All right.
See you. Forgot about that one. All right, let's get to our status hearing calendar. Position one, and we're not going to bring folks. I'm going to get through the calendar, just see what's going on, and then we'll figure out who's coming out. Position one is Salahuddin Haynes, who's got an AKA, which is the name he normally goes by. That's Mr. Fortis's client. Mr. Fortis, you still with us?
I'm with you, Judge. How are you today?
I'm all right. So if I'm remembering correctly, Mr. Haynes, AKA different name, had like, I'm exaggerating, but like 10 unindicted cases. And we've been trying to wrap our arms around all that and sort it out. Should I get an update from you or from Ms. Charles?
I think I can provide it to the court.
Great.
So the last time we were before Your Honor, we put this on a status because he had obviously a slew of cases and obviously he had a violation of probation pending before Your Honor. And I think that what we had discussed was to bring all of those cases, including the violation of probation, before Your Honor. And we were trying to work out some sort of treatment plan. And what the court had recommended for us to do was to reach out to drug court. And I guess it's just timing or whatever, but yesterday I received notification from drug court that he is accepted into the drug court program. So I spoke with the prosecutor today, and what we want to do is schedule this for a plea on all cases. I would like to advise the court that there are 2 or 3 non-complex cases that appear on a calendar on Friday, and my understanding is that we're going to get those cases and put those before Your Honor so we can do a plea on all matters, and it's going to be a drug court plea. That's my understanding.
Fantastic. I appreciate people following that little suggestion, and I'm happy that drug court accepted. What is your client's real name?
I put him by Mr. Smith.
That's right, Mr. Smith. Ian Smith?
Correct.
Okay. Ms. Charles, is that your understanding of what's happening?
Yes, Your Honor. In fact, I talked to Ms. Nelson to see what's the earliest date we can sort of be put on the calendar to take that plea.
What is the status of you being able to accuse the unindicted cases?
So I'll be working on, Ms. Nelson, the earliest that we might get is June 9th. And so I'll be able to get that done well before then.
Oh, Ms. Nelson said that's the earliest date we could get.
Set to take the plea. So
Okay.
I'll have enough time to consolidate and get ready for the plea.
And then you'd let Ms. Nelson know these are the 2 non-complex cases we should grab as well.
Your Honor.
Okay. So you think by that June 9th date, you'll have all the pieces you need. Mr. Fortis will need to get with Mr. Smith so that Mr. Smith appreciates, gosh, it's a lot of moving parts, but I'm okay with that.
Yes, Your Honor.
Okay. And that would obviously include the revocation as well.
Yes, Your Honor.
Okay. Mr. Fortis, anything you want to add to that?
I would just say this, if we're going to go with the June 9th date for whatever Ms. Charles is not able to indict, if there's a waiver there, I'll come in person and we'll execute a waiver in order to expedite things if we need to do that.
Oh, I think already we're talking about accusations and not indictments. Am I correct?
Yes, I'll reach out to Mr. Fortis. If I do need a waiver of indictment, I'll send that email to him and we'll get it worked out.
Okay. Yeah, you may not, given the way the statute was amended because of the pandemic, but please do coordinate with Mr. Fortis because it sounds like he'll get you that waiver.
Absolutely. Thank you.
Okay. My thought then is to let Mr. Fortis get out of here. Let's just bring Mr. Smith to the door and I'll tell him, hey, it sounds like June 9th, there's a global resolution and Mr. Fortis will be in touch with you. Does that work for you, Mr. Fortis?
It does, Judge. If you would also tell him that he's been accepted into drug court, because I just got that information yesterday, so he doesn't know that as of yet. So if the court would just advise him of that, that'd be great.
Will do. And is 9 June an in-person or a virtual?
It's gonna be time in the spot.
Okay, we'll be borrowing someone. Okay, so in person. Hey, Mr. Smith, how you doing? I don't know if I've seen you in person. I know I've seen you on the screen a bunch of times, but
It's been like a year.
it's been a year. So Mr. Fortis is on the screen. You can stay right there. It's gonna be real quick, but I just wanted to give you the updates. They're good updates. You've been accepted into drug court. And Mr. Fortis has been working hard to arrange a global resolution. You've got the real old case that you had. I assume it was with Judge Downs or someone's docket that I inherited. That's why we're doing business with that Salahuddin Haynes name. You get your new unindicted cases, but the prosecutor, Ms. Charles, is going to get those charged. And you've got 2 cases that are bouncing around in non-complex. Those are all going to be brought together. And on June 9th, so a couple of weeks from now, you'll be back here. Before then, you and Mr. Fortis will be talking because it ought not to be a surprise that you're here on June 9th. And according to Mr. Fortis, you'll be prepared to enter a plea to all those things. We handle the revocation, the end result being, because you've been in jail for a long time, effectively time served, released to drug court. Does that make sense? Important question. Do you have a place to live, or does drug court need to line up some provisional housing at first?
I believe I was just staying with mom.
If your mom will let you stay with her, that's fine. Drug court doesn't have a requirement.
Sure she will.
All right. You may want to reach out to her, say, Mom, what about like June 10th? Got to come back.
I have a question. I have a court date on Friday.
You do. Mr. Fortis, he flagged that. He said, hey, by the way, Mr. Smith's got a court date on his non-complex cases. Nothing will happen with him then. You may be brought over because you're not supposed to miss court, but someone is letting non-complex know that I'll handle those pleas on June 9th. Okay? Any other questions? No? Mr. Forrest, I don't know if you can hear it, but Mr. Smith says cool.
I heard him, Judge. Thank you very much.
Excellent. All right. June 9th. We'll see you. Thank you, Mr. Fortis.
I think I have one more matter before the court.
Oh, well then don't leave. Next up are two cases involving Kentevius Jackson. And I don't know who the lawyers are.
That's Mr. Fortis.
That'll be me, Judge.
Fortis. Well, he lucked out up front. Okay. So
Judge, what I would ask the court, Mr. Jackson has a matter right now pending before Judge Edwards, and we are slated to complete that case toward the end of June. I would ask the court, if you would, to move those matters so we could do a global resolution before Judge Edwards.
So it would be me asking Judge Edwards if she would be willing to handle the revocations in connection with the plea in her courtroom.
That's correct, Your Honor.
Okay. Ms. Charles, do you have an objection to that, or were you thinking, hey, these ought to be handled here?
Your Honor, I spoke to the attorney in Judge Edwards's courtroom.
Meaning your colleague?
Yes, Miss ADA Simmons.
Okay.
And based on what she's told me as to where the status is of this case, I think we could wrap up the revocation today and then let the indicted case, Mr. Jackson has an unindicted case as well that, based on what Ms. Simmons said, could be wrapped up at the end of June. But I thought perhaps we could he's been in custody for 168 days so far. I would recommend we revoke 6 months, reinstate on probation. That would close out his probation cases. And then the cases in Judge Edwards can just continue.
Okay. I don't know if you heard that, Mr. Ford. Were you able to hear Ms. Charles?
I was, Your Honor.
So, I mean, we can bring Mr. Jackson out here, and as long as you don't mind having the basic conversation with him, with us here, we could take care of these two with the 6 months revocation, close out those two cases, so that really all that Mr. Jackson is navigating with you and Judge Edwards is the new indicted case and the unindicted case.
That'd be great, Judge. Let's do it.
Great. Can we bring Mr. Jackson to the podium, please? I like the suggestion, Ms. Charles.
Thank you, Ms. Charles.
You're welcome.
Next up, just for people's planning purposes, is Mr. Muckle. And we'll just bring him straight out when it's his turn, because this is just a chance for Mr. Granums to say, hey, I'm your lawyer now, and we'll talk about discovery a little bit. What case are you all in the third row here for? Got it. Okay, it's on here. Mr. Jackson, how you doing?
Hey, how you doing, sir?
You can see your lawyer, Mr. Fortis, on the screen there.
Yes, sir.
So I want to just give you an update of what we're thinking of doing, and then you can hear from Mr. Fortis on this. You have with me, I'm Judge McBurney, 2 revocation matters. I don't think I'm the one who took the pleas. It was probably Judge Downs, but I inherited her cases. But regardless, they're mine now.
Okay.
what the state was going to recommend, the basis for the revocation is that you've got new charges. You've got a case with Judge Edwards, you've got an unindicted case. The state was going to recommend revoke 6 months and close out those cases with credit for the time you've been in. You've been in just a little less than 6 months. And that would mean you and Mr. Fortis can go deal with the prosecutor in Judge Edwards's courtroom. Ms. Charles, the prosecutor here, thought it probably will be the case that you can resolve both your new charge with Judge Edwards and an unindicted case together and move in that direction. But her recommendation was, let's just knock out these 2 revocations here. Mr. Fortis, having heard that, said, that makes sense. Let's just close those out. But of course, you're the one who has the cases, not Mr. Fortis or not me. You okay going forward?
Yes, sir.
Do you need to ask Mr. Fortis any questions?
No, sir.
Okay. So then on the record, in case 19 SC 167087 and 19 SC 167500, it is alleged, Mr. Jackson, that you violated the terms and conditions of your probation. These are both entering auto cases well, one of them is entering auto, one is a robbery by sudden snatch, and one entering auto count. Either way, that you violated your probation in those 2 cases by committing the new offenses that you've got with Judge Edwards and this unindicted case. Mr. Fortis, is Mr. Jackson admitting to the violation?
For the purposes of this hearing, Your Honor, we're admitting.
Sure. Okay. Ms. Tucson, how much time remains in the case ending in 087?
087, he has 1 year and 9 months left on probation.
Okay.
2022-2024.
Got it. And the case ending in 500?
That one ends June 16th, 2024.
Okay, so that's got about 2 years left. Ms. Charles, your recommendation was to revoke 6 months and suspend the balance or keep the balance going? I may have misunderstood what you were saying.
Keep the balance going.
Okay, so that Mr. Jackson would remain on probation in those 2 cases, but his revocation would be over in a short period. Okay, all right. Mr. Fortis, anything you want to add about Mr. Jackson's cases?
The only thing, Judge, is that when we complete the probation, the pleas in Judge Edwards, there's going to be terms of probation that are going to follow that. So I just want to avoid anything that may be duplicative in nature and or multiple probations. He doesn't have a lot of time left before these cases, but he's going to get probably some new time that's going to exceed this time that Your Honor's reinstating. So just keeping that food for thought and moving forward. Less would be more, I guess.
Sure. I hear you on that. Tell me what Mr. Jackson's bond status is. Let's say hypothetically, Judge Edwards defers by a month because something comes up, resolving Mr. Jackson's case so that his revocation ends in this case, because it's 6 months. Would he then be released, or is he in a no bond status with either Judge Edwards or the unindicted case?
Right now, we're in a no bond status, Your Honor.
Okay.
Our intentions are to complete the case at the end of June, and that would effectively terminate both of those cases as far as the open case, but there will be a term of probation. I don't see a scenario where he makes bond in lieu of completing the cases.
Got it. Okay. Mr. Jackson, do you have any questions about anything we've talked about?
No, sir.
Okay. Well, what I'm going to do in 19 SC 167087 is revoke 6 months. You'll get credit for the time you've already served on your current arrest, and I will suspend the balance in that case. In the other case, 19 SC 167500, I'll also revoke 6 months. That revocation will run concurrently at the same time with your other revocation, but I'll reinstate the balance only because I want to make sure there's some form of supervision. Should things unfold a little differently than Mr. Fortis thought, maybe the state says, oh, we need more time, and Judge Edwards says, well, you said you'd be ready and you weren't, so I'm giving Mr. Jackson a bond. I want the supervision in place. If for some reason the way the Judge Edwards cases resolve is no probation at all, Mr. Fortis, you're free to come back here to say, "Oh, wait a minute. Originally, there wasn't going to be any probation left in the two McBurney cases. And now it's the only thing Mr. Jackson has." I'm hearing you say that's not the plan. The plan would be that there'll be probation from Judge Edwards anyway, but plans have a way of changing. So I'm going to leave the probation in place in the case ending in 500 after the revocation, just so there's that little safety valve in case things in Judge Edwards turn out differently. Ms. Charles, anything else in connection with Mr. Jackson's cases? Mr. Jackson, any questions about anything I just said?
No, sir.
Okay. Mr. Fortis?
One last thing, Judge, if you would just specify that he's going to get credit for the 167 days, just so there's not any miscalculation with time, even though he's been in continuance.
Sure. So what I don't do is give a specific number because you and I are lawyers and our math is bad. But what I'll do, we can figure out the date. There'll be some date of arrest, and that's what will go in the revocation order, credit from date X. And we can find out from Odyssey the date that Mr. Jackson was booked in, and that's the date we'll use.
They're asking, I don't have that information in front of me on this particular matter.
No, but we can get it. Don't worry. We'll
That was me who asked him about the date he was arrested.
Okay. Well, Ms. Nelson can figure that out.
Okay.
All right.
Thank you, Judge.
You bet. Well, you may know. When were you arrested?
December 7th.
December
7th.
December 7th of last year?
Yes, I was booked on the 8th.
Booked on the 8th. So December 8th of 2021. Credit from then. So that is real close to 160, whatever he said. About a week left. All right.
Thank you, Judge.
You're welcome.
All right, Mr. Jackson, I'll see you in June.
All right, thank you.
You're welcome. Thank you, Judge. That's all I have.
All right. Take care.
It's good to see you. Thank you, Ms. Charles.
You're welcome.
We are ready for Mr. Muckle, please. I thought that I was confused. Like, wait, no, we're supposed to have this guy who does anything auto. So that's who I really thought, like, whoa. Because it fit. Like, I'm getting more now. Mr. Pierce will be after Mr. Muckle. Oh, that's not chat, but instant message. Does she get that? Chat in the Zoom. Okay. Hey, Ms. Tucson, please check your chat or your email. Ms. Nelson's trying to get you some information. Hey, Mr. Muckle, if you don't mind coming to the podium, you'll be able to see your lawyer better that way. All right. Mr. Muckle, I'm Judge McBurney. I don't think we've met, at least not face to face like this.
Yes, sir, you're correct.
Your case has been assigned to me. And we have been able to get a lawyer appointed to represent you. That's Mr. Granums. You'll see him on that screen right there. He is new to your case. He is not new to the practice of law by any stretch, but fortunately, he has agreed to take appointments. There was a conflict so that the public defender could not represent you. And then we have a conflict defender. They had a conflict in representing you. So Mr. Granums is that third level of, hey, we need a good lawyer. And he is able to take some of those cases. Yes. That's Mr. Granums. He's new to your case. Mr. Abate, who is back there, is, I think, the prosecutor on the case?
Yes, sir.
Excellent. Had you previously served discovery on a predecessor attorney?
Yes, I served on Mr. Gordon Bowles, I believe, back in.
Oh, that's right. Mr. Bowles was the C3. Okay.
I'm assuming that Mr. Grannis probably doesn't have a copy.
Well, I'm going to ask. Okay. So Mr. Grannis, tell me what your situation is with discovery.
Well, we do have Mr. Muckle's discovery. We received it recently from the previous attorney. We're in the process of going through it and reviewing it for completeness at this point.
Okay. Have you worked with Mr. Abate yet, or will this be a new relationship for you?
No, Your Honor, I have not.
All right. Well, he is easy to find and will be very responsive if you believe you're missing parts of the discovery. What do you want to tell Mr. Muckle in terms of when you will reach out to meet with him to start discussing his case and what's next?
Yeah, Mr. Muckle, we're in the process right now of looking at your discovery, both myself and my investigator. After we get a chance to look through it and review it all, we're definitely going to want to both come down and talk to you and go over it with you. I'm not sure if your previous attorney has gone over the discovery with you or not yet at this point. Okay, so we'll go over it. We'll give you a chance to take a look at it. And then we'll have a discussion about what's going to happen next. I would expect that I would probably be coming down. Let me look at my calendar here real quick. Sometime next week in the maybe Wednesday or Thursday of next week. Okay.
Okay.
We'll come down. We'll get an opportunity to meet you. You'll get an opportunity to meet us, and we'll go from there. Okay.
Yes, sir.
Mr. Muckle, you're at the county jail. You're not in Cobb. You're at Rice Street.
Yes, sir, I am.
Excellent.
Thank you.
Okay. So Mr. Granums will come see you. There may be some of the discovery he's allowed to leave with you. Paper you can have. Obviously, if it's like a thumb drive, you don't get to keep that, but you may be able to keep some of the stuff if he's got a copy for you. Mr. Granums will then need to file any motions if he thinks there are motions that need to be filed in your case. A classic example is if you spoke with the police, it may be that Mr. Granums thinks that should be suppressed because of the way the police conducted the interview. He may have no motions, and that doesn't mean he's not working hard on your case. It just means this isn't a case where there's something to suppress or to challenge short of the trial. The ultimate goal is to get your case ready for trial or a non-trial resolution if you and Mr. Granums think it can be worked out. Given the charges, this is the kind of case that typically goes to trial. You've been in jail for over a year. It is high time for you to get into court to have your trial. But number one, Mr. Granums needs to get up to speed so he can effectively represent you. And number two, while a year seems like a long time, unfortunately, we all have cases, all the judges, where we've got inmates who've been in for 2 years waiting for trial. And we generally try to try the older cases first if they're ready to go. But if yours gets ready and the other one's not, we'll try yours.
Yes, sir.
So look forward to a visit from Mr. Granums. Mr. Granums, I guess we should do a scheduling order, just so you've got a deadline to file motions. So we'll do another scheduling order. This case is more mature than the other one you picked up today in that another lawyer looked at it, didn't meet with Mr. Muckle, but at least you've already got the discovery. So I'll have Ms. Nelson do a scheduling order just so we can get a deadline for motions. If you determine that that deadline's not going to work because there's some discovery missing, let Ms. Nelson and Mr. Abate know and we can adjust it.
Okay, thank you, Your Honor.
Mr. Abate, are you aware of any discovery that Mr. Granums is not going to find because you're still waiting on a crime lab report, or there's that cell phone you're hoping to extract?
There's no cell phone that I'm aware of in this one, thank goodness. And I believe all the discovery was served to Mr. Bowles, but I will, as soon as I get back to my office, double check.
Okay, great. So Mr. Granums, you should have everything, not a guarantee, but it should be there. If Mr. Bowles gave you everything, you've got what the state has.
Thank you, Your Honor.
Excellent. So Mr. Muckle, we'll see you either for motions or for a final conversation before trial.
Yes, sir.
All right, you're welcome.
Any type of way I can get his number and all that right now?
Mr. Granums, is there a phone number you're comfortable sharing with Mr. Muckle?
Well, we're concerned about receiving phone calls from the jail because they're recorded for the most part. And I worry about discussing the case and possibly waiving privilege. We prefer not to take calls directly from the jail for that reason.
Why don't you, when you see Mr. Muckle next week, guys can talk about that more. We may need to set up for you, I don't know how we do it on a provisional basis. There is a way that the public defender can call the jail and those are not recorded.
Okay.
Am I making that up or is that true?
They're also supposed to, he can turn his number into the sheriff's department, and every attorney who provides the number saying that they're counsel of record, Securus does not.
I thought that was right, but they verify it so that it's not Mr. Muckle's best friend who says, hey, I'm his lawyer. So Mr. Grandams, you may want to explore this with the sheriff when you are next out at the jail. But Mr. Abate was reminding me, I don't know if you have to show your bar card or your entry of appearance, but if you provide a single number that is yours, then if Mr. Muckle is using that, he's dialing that number, that does not get recorded.
Thank you, Your Honor. We will go ahead and get that set up.
Okay, great.
All right. And then, Mr. Muckle, as soon as we do, we'll have that for you. We'll also have a number for, the office of your family members can contact us as well.
Okay, thank you, Mr.
Okay.
All right, thank you.
Thank you, Your Honor.
All right, is Mr. Pierce here? Is Mr. Pierce in custody or is he on bond? It says a $1 bond. I never know what that means.
I believe, yes, Judge, this is the gentleman, it was discovered to be a conflict earlier this year. He was reset, I believe, for Miss Bernard to try to find him.
So I'm looking here, there was a plea and arraignment in February, one in March, and then this. Did he ever show up to any of it?
It was Miss Patel's client. I don't think that he did.
So we may just need to put this in bench warrant status and judicial hold. Okay. No, I do. Yeah. But your belief, Ms. Wood, is that your office cannot handle this.
That was I remember that Miss Patel reset it a couple of times for conflict to be linked up with Mr. Pierce.
Okay. Because of the alleged victim, or you don't know, or you're not supposed to disclose that?
I can find out, Judge. I really.
No, it doesn't. I'm just curious why, because you're sort of tentative on it, but it sounds like you're tentative because, hey, it wasn't my case at the time. I just don't know the answer.
Right. I just
Okay.
remember her having issues, having him come into court.
Got it. So Ms. Charles, I don't know how the whole bench warrant thing works, but one of you be in touch with the other, and then we'll put it on judicial hold. All right. How about Christavius Jerome Smith?
Good afternoon, Judge.
Hey, Mr. Richardson. I'm well. You were a hot topic yesterday.
Oh, yeah, I heard that.
Yeah, I heard it too. Mr. Weintraub was. Is Mr. Smith here? Before we bring him out, let's just chart what we're doing here. So I've got 4 cases.
4 cases.
Do you have all 4?
I'm not sure. I have a bunch of cases that deal with driver's license and then I understand there's supposed to be a burglary case.
So there's a fleeing or attempting to elude, another fleeing or attempting to elude, a burglary, smash and grab, and then well, it's a misdemeanor obstruction, but allegedly a gun, and that's the felony. So these are all things that are like state court, superior court, teeter-totter, but they're here. All 4 are here.
What's explained to me is that he had a bond. He also had a probation problem. And because of his probation problem, the court revoked his bond on his gun case. And now his probation has run its course and expired. And I'm back to get his bond back.
Okay, but not to resolve his cases?
Well, I mean, certainly 3 of them, but I wasn't aware really until Ms. Nelson made me aware of the smash and grab.
Okay.
I hadn't been retained for those.
What's the case number for which you've been retained?
I think it's 297, 697, and maybe 214.
Oh, you've been retained for 3 of them.
Yeah,
Okay. There's a 214.
214, right?
So that's a fleeing and attempting to elude.
I see a 954, which is fleeing attention to.
Yeah. The 297 is the smash and grab.
Oh, so that's not mine.
That's not, okay. Well, you're just making it up now because that's the number you gave me.
Oh, I'm sorry.
That's okay. But you represent Mr. Smith on 3 of the cases. Okay. And am I the person who revoked his bond because?
Court file, yes.
Huh.
22, looks like.
Okay.
Order revoking bond was.
In which, I guess I'm gonna call one of these up and see if I can get some info. Well, why don't we bring your client out?
Sure.
Mr. Smith, please. Is that, I think that's our last jail case. Let's see. Okay. Where's the orange suit? Oh, Cobb. Okay.
I got it. Please. Did the bond use much? You give you one. So Judge, the smash and grab charge, he apparently was given a bond first appearance. So he has not retained counsel on that. I'm not opposed to being retained, but to date, he has not. And I just spoke with a prosecutor. She believes that certainly 3 of them, I don't know anything about smash and grab yet. We should probably be able to fashion something that would resolve his cases.
Okay. So let's get our bearings on all this. Mr. Smith has a lot of moving parts, busy last few months. Mr. Smith, I'm Judge McBurney.
Hey, how you doing, Your Honor?
I'm okay. How are you doing?
Good, just ready to help the family back out.
How's the Cobb County Jail? Not good?
I can't see family. I'm ready.
Is there no visitation or it's more limited than at the Fulton County Jail?
I just due to my fiance can't make it with the arrangement with me not having the help at the house sometimes.
Just small children, maybe a special needs person.
Okay. So here's where we are. In one of your 4 cases, 22 SC 180954, you were given a $16,500 cash bond by Judge Drake, very beginning of this year, January 13th. You were subsequently indicted for burglary in the case you're not on yet, Mr. Richardson. And I revoked your bond in the case ending in 954, fleeing or attempting to elude, because you were indicted for burglary. It's not that probation has ended. It may be one of his other bonds got revoked for that reason, but this bond was revoked because of the subsequent indictment for the burglary. Which is a continuing condition, not an expired condition. So that's where we are. I don't know if, Mr. Richardson, you want to talk with Ms. Charles about resolving the other 3 cases, because if they're resolved, it sounds like there is a bond on the burglary case. I don't know who set that. I clearly didn't set it. But I don't know that I did anything with the bond in the burglary case. I'm going to look in just a second. But I just wanted to, we spoke, Mr. Smith, before you came out, Mr. Richardson and Ms. Charles and I just talked a little bit about what are we going to try to do with these cases, because Mr. Richardson was clear. I've got 3 of them. but I don't have the fourth one. And he ought not to represent you on something where he hasn't raised his hand to say, I'll do that. He may choose to do that after talking with you or your family, but until he does it formally, he can give you his thoughts, but he's not your lawyer on that case. How would you like to do things today?
The judge, as I understand it, if Ms. Charles and I are able to work out 3, the other case is bondable?
Well, I'm going to look right now. I don't want to misspeak because, like I said, there are a lot of moving parts for Mr. Smith. Yeah, I'm just looking. Thank you, Judge Adams. Any other cases coming, or that's your last one? Are you aware of any unindicted cases you've
No,
got?
sir.
Okay, all right. So to your question, Mr. Richardson, there is another Judge Drake bond, a $15,000 good bond set for the CP version of the indictment. Now, so we're clear, the state added one more felony to it. So we could talk bond, but he'd need a different bond because that first bond only covered the burglary. And then ultimately, Mr. Smith was indicted for the burglary and criminal damage to property in the second degree. But I'd be happy talking about that.
Less severe offense was added.
Probably less severe. My guess is it was a side effect of the burglary.
Broken window or something?
It's doors and display cases at Alexis Suitcase. So there was the alleged smash and grab burglary at Alexis Suitcase. And it might even be something that would merge. I'm new to the smash and grab burglaries, but because it looks like an element is you cause damage, and then the criminal damage to property is the same damage, it might even be a merger. But there needs to be a bond on both counts.
So Judge, I think you have Ms. Ortiz next. Can we ask him to go in back and have a moment with the state if she has a moment?
You bet. So Mr. Smith, what I'm going to do is have Mr. Richardson talk with Ms. Charles. It may be that Mr. Richardson could resolve. I mean, ultimately, you need to be okay with whatever the recommendation is. The 3 cases that don't involve Alexis Suitcase. If those are resolved, then what would be holding you in would just be a bond situation that we could also address today, because you technically don't have a bond on the second count of the Alexis Suitcase case. But that's assuming that the state would be recommending something that's kind of time served for you. They may recommend 10 years to serve and you could resolve it, but then you'd just be changing jumpsuits. And I'm guessing that's not what you're interested in today.
Yes, sir.
So I'm gonna have Mr. Richardson talk with the prosecutor and he'll come back. We got Ms. Hall, good. All right, you two are done, I think.
We were just sticking around to see if there was anything on here that we could help clarify for the court. So maybe we'd be excused.
I think so. Are you Mr. Cooper?
William Kitchens for Bill Kitchens.
Okay, you are associated with Mr. Cooper.
I'm just an interloper judge.
Okay,
I'm counsel with that.
great. Then yes, you guys are good to go because we've got lawyers for well, I'm assuming Mr. Richardson will pinch hit for Mr. Smith on that bond issue. So you should scram while you can.
Thank you, Judge.
You bet. Mr. Kitchens, why don't you come on up with your client? Mr. Abate, I think you're done too, unless you need me.
I can take this. God, the rest of the day.
Shorter than yesterday.
Yeah, well.
What's the voting?
No, you're welcome to just sit at defense counsel table. Ms. Hall is going to be on the screen. So why don't you guys just sit over there?
Kept calling that other attorney Mr. Grant, but I'm pretty sure that was Connor McGregor. Right here.
To see him in person.
He was just like him to me.
All the tattoos were covered up.
My client says he needs an interpreter, Judge,
Okay.
but this is just a status hearing, so.
Well, it's more complicated than that, because there's a bond issue. So we'll reach out and see if, that's okay. So let me see if we can get an interpreter here. Actually, two of them walked down the hallway, during the lunch break. So we'll put out, let me tell you what I think the issue is. And then when there's an interpreter here, he or she can get Mr. Ortiz up to speed. There is a bond in the case, but it was a bond that was set before this was indicted. And new charges were added. And so sort of like what you heard me talking about with Mr. Richardson and his client, Mr. Smith, the bond doesn't cover everything. So I need a chance to, hold on one second.
I was looking for a copy of the indictment in my file. I didn't have it. You have a scheduling order that said discovery is supposed to be sent to us by the 20th of this month.
Well, we'll talk about that too if you don't have
I was
discovery.
hoping to get the indictment and all that within the discovery package, list of witnesses, et cetera. You want us to not take the table for the moment, or you want us to wait on the?
No, take the table. Just get comfortable. So the state provided discovery, Mr. Thomas did. I don't know that he's on the case anymore. Mailed it to Mr. Cooper at 5855 Jimmy Carter Boulevard, Suite 155 in Norcross.
That's correct.
It was the indictment and an electronic link to some warrants, photos, 9 segments of body camera video, et cetera. So you all are gonna need to follow up because the state's gonna say we already sent it.
That's fine. Sometimes it doesn't hit the file. What date was that? Do you know?
Yes, that was e-filed on April 28th.
Okay. That gives me something to look for. Okay, of this year.
Yes, of this year.
Okay.
And an interpreter is heading this way.
Okay.
Did you do that or Tom just sent something? Hey, can you need an interpreter? Okay, excellent.
Judge, where do I know you from? How long you been on the bench?
10 years and 1 month.
Were you state court before you were here?
I was not. I was a federal prosecutor.
I think that's where I know you from, before the bench.
You were a federal defendant?
Yeah, that's right. You were real easy on me.
Yeah, apparently. You kept your license.
A judge I clerked for is now on the federal bench. Judge Steve Jones.
Oh, yeah. He started just a few years before. Oh, hi, come on in.
And of course, we had Judge Billy Ray in the Gwinnett Circuit before he went. Please.
Voy a hacer, siéntese ahí. Voy a hacer su intérprete.
Okay.
All right, I'm going to swear in the interpreter and then we'll get going. Do you swear or affirm that you will interpret from English to Spanish and Spanish to English to the best of your ability and training?
I do, Yana.
Thank you. Good afternoon, Mr. Ortiz.
Good afternoon.
The way we're going to use the interpreter is that she will translate everything that is spoken in English to Spanish. Even if you understand the English.
No.
Even if you understand the English, you need to wait until the interpreter is done translating. then you're free to answer if it's a question in English or Spanish, but the interpreter will repeat your answer in English, and that will be your official answer. Do you understand that?
Yes.
Great. So the issue we have is with the bond that Judge Osby, O-S-B-Y, entered on May 17th of last year. That bond was a $9,500 good or cash bond. But it was for one count of aggravated sodomy and one count of family violence battery. Mr. Ortiz's indictment includes an additional count of rape and of criminal attempt to commit aggravated sodomy. He doesn't have bond for those two counts, but he is in general circulation, so we need to fix that. Ms. Hall, what's your recommendation as to what we ought to do? Well, before you give that, I should add that the indictment, while adding those two charges, is not adding a different incident. It's the same date. Either the state learned or believes that there was additional conduct involving the same alleged victim, or it wasn't fully articulated when the complaint was drawn up. But it's not a separate set of facts, if that makes sense.
Yes, Your Honor. That is correct. It is the same victim, same incident. When we looked at the case, we felt like we needed to add additional charges. I've spoken with the victim. I'm sorry, let me slow down. I've spoken with the victim in this case. She's indicated to me that she's not afraid of her ex-boyfriend. They have been in a relationship for 20 years. This is not an incident that's happened in the past. This is the first time something like this has happened. She did indicate to me that she was trying to get a restraining order because it is her desire that she has absolutely no contact with him, meaning no contact at her home or her person. However, they do share a child together. So she said that if he's interested in speaking with his child, which is a 17-year-old son, she don't want to get in the way of that. I did ask her how she felt about her ankle monitor. She said that she wasn't interested in that. Her only concern is him staying away from her, and she's not afraid of him. So the states, I know this is just the adding on the additional charges that we need to get a bond set for.
Well, it's not just a just because it's a real serious charge.
Right. So, Your Honor, I don't have a number. I do know that there needs to be a number set to that serious charge, but after talking to her, in looking at his GCIC, this is his, he has 2 cycles, one being this cycle, the other being a driving with a suspended license or driving while under the influence of alcohol. So taking in consideration their relationship, what happened that night, his criminal history, I haven't come up with a number. So I was going to leave that to your discretion. The victim is not interested in speaking about the case right now. She's still really shaken up about what happened. So she didn't want to be a part of the Zoom hearing and she didn't want to speak with you about it. But I did tell her I would convey all of this information to you so that you can take it in consideration when making or giving him a bond or not for these additional charges.
Got it. Thank you.
You're welcome.
Do you know, I don't know if this is a question for the deputies here. If I am modifying the bond to include more money, does that mean that Mr. Ortiz needs to go back into custody? Or how?
I
People
think
are nodding their head. Okay.
Yeah, I think so. And that's why I didn't really have a number, because I know that will include him going back into custody. So I didn't know how we would figure that part out, because there is an active warrant that is in the system. So I think he will have to at least clear that warrant, maybe with whatever is added to those additional charges.
Okay. If there's a warrant in the system, then it's not like we can do anything anyway. You have to clear that.
And it
Okay.
is. You should see it in Odyssey. I was able to pull it up before court started.
Okay. No, I don't doubt it. I'm looking at the bond right now. Okay. All right. Mr. Kitchens.
Couple of disturbing concepts. He's arrested for one thing, he's indicted for those things, and then they indict for something else. That's not uncommon. They certainly have the right to do so, and I'm not arguing differently. That it resulted in a warrant, though, is a little strange. I think they could have indicted him without, because once they go to the grand jury, I don't think it has to result in a warrant. Maybe I haven't seen that in a long time, if ever. But if there's an active warrant, I tell all my clients, warrant is satisfied by arrest. And it sounds like there's gonna be no way I can talk him out of that today.
So I agree. So
Bond.
yeah, let's talk about that. And to be clear, based on what Ms. Hall has said, in particular, what she has represented from the alleged victim, I'm not in my mind thinking, okay, 100,000, 200,000. That's not my point. There needs to be a bond. It needs to reflect the situation, but something about this situation prompted a judge to set a less than $10,000 bond on a pretty serious charge anyway.
We had to file an indict or release motion. He'd been held over 140 days.
Okay.
I had that in my folder. That's how I knew that myself. And I'm thinking that that's maybe why, without having been there myself, I wasn't the attorney that was at that particular hearing. But being held 140 days when they have 90 days to indict or release, I think the judge may have given him some benefit of the doubt there. I'm asking this judge to give him benefit of the doubt as well. The bond is frankly low for an aggravated sodomy, and in my mind, an aggravated sodomy is no less serious than a rape. They both carry a lot of years, and I don't have that to mind, but I think they carry the same amount. I think aggravated sodomy is one of the 7 deadly within the statute. The Superior Court only bond, so very serious charge in the first place, and they gave him 9,500.
Well, and so we're clear, I'm not sure that that judge was authorized to set the bond that she set. We have a policy in place that directs certain offenses to elected Superior Court judges. I think this was one of them. And so someone dropped the ball. I'm not faulting the magistrate. Probably the prosecutor should have been jumping up and down saying, wait a minute, you don't hear this.
That's the Superior Court only bond.
Well,
I haven't looked it up, but
the Superior Court can delegate authority, and the Superior Court in Fulton County has, but it pulled back the authority for murder, rape, aggravated child molestation, and a few others. I just don't remember off the top of my head.
it up either, because I didn't know we were gonna have this issue when we walked in.
Well, and it's not look upable for you. It's a internal policy.
Oh, you're talking
So
about Fulton County.
correct.
I thought you were talking about statute change.
Nope.
So I guess the point I'm trying to make, maybe inartfully, is that $9,500 got him here today. He's obviously not dipping or ducking. And I would suggest that maybe, this is gonna sound ridiculous, I'm sure, but spread that 9,500 across all charges. He's already posted it. The district attorney, we had to file a motion to even get a bond. And here we are on the same incident, same victim, arguably the same acts, alleged acts. And he's here anyway, so I would ask the court to spread that bond across all those charges.
There's a certain logic to that request. So I don't think it sounds ridiculous, other than that we're starting with a number that to me probably was a little off kilter, other than your observation that if you're at day 91.
Quite frankly, if I have a $9,500 bond on Ag 7 and a rape, I'm gonna brag about that. Even though I wouldn't give it full justice unless I told the whole story. It seems, I agree that on its face, it seems low. But at the same time, we have some demonstrated history here. The fact that he did bond out, he is still here, he is showing up for court. And quite frankly, Judge, the district attorney kind of outlined a case which seems very triable to me. She mentioned a 19-year history. Not that even married people can be raped. I'm not saying that. I don't want to get sideways with that concept, but 19-year history, she says she's not scared of him, but at the same time, she wants to get a restraining order. Well, an essential element of the TPO is that you're fearful. So it sounds like the victim in her own mind has some issues that are going on. I don't know. I'd have to see more of the discovery to see what happened.
Right.
Better argument on that.
Well, that is going to be your project, is to track down that discovery.
We will.
Something? No. Oh, okay. I thought you had. Okay. Where is Mr. Ortiz living now?
I'd have to defer to him. The last time we did a address change, it was at 6. I had it right here, I thought.
I'll help out. Are you staying at 668 Stonecrest Drive in Loganville?
I did it. Yes.
That's the one I had for the address change.
Who lives there with you?
My sister.
Is your sister here today? Great.
Yes.
Okay.
And she speaks English.
Okay. That's why she raised her hand.
Speaks English. She admonished me that I'm not more bilingual considering my wife's Colombian. But I'm a slow learner.
Okay, I can't believe she's withdrawing from that case. All right. Mr. Ortiz, do you understand that I need to set a new bond for you because you face more charges now than you did when you were arrested?
I understand what you say in Spanish, but I don't know what are the charges that you're adding.
Can you say that one more time?
He understands what you're saying. He just doesn't understand what the charges are that are being added.
Got it. Mr. Kitchens will talk with you about what's in the indictment, but the charges relate to the same incident for which you were arrested. And I will print out a copy of the indictment for you to have now.
If you don't mind, Judge, that'd be helpful. Thank you.
Ms. Hall, anything else you want to add?
No, Your Honor.
Okay. Mr. Ortiz, I don't know the facts that prompted the other judge to give you what seems like a very low bond, but the only thing that has changed since you got that low bond is that you've been charged with 2 additional crimes. You showed up for court and you have left your former girlfriend alone, which are the 2 most important things you've needed to do. So the bond I'm going to set will be $5,000 for each of the 4 counts. So total bond of $20,000. Mr. Kitchens, I am neutral as to whether that is a good bond, meaning through a bonding agency, or through the sheriff's 10% program, so that the people who put the money up get their money back when the case is resolved. So if you want to talk with Mr. Ortiz or his family about their preference, I just need to know so that I check the right box, the correct box on the bond order.
You give them the option, check both boxes.
No, it will then be rejected as not a valid bond order.
You understand the question? Matt, may I inquire across the court? Did you help him post a bond last time? Y'all went for the bond? Y'all prefer that again? You know, the sheriff has a 10% program. Criteria are, I don't put you in one program.
Y el sheriff, cuando todo se cierra, le regresa el 10% del dinero que
I
está.
think going through a bond may be safer on that, but it's gonna be more money.
Pero si lo hace previo,
I'm sorry? Bondsman?
Probably so. I don't know how that works. I mean, that's.
I'll talk to you, but I think bondsman would be better, because this would give you options, bondsman all over.
si lo hace a través de la casa de fianza, tiene
I
más
think
opción. Yo creo que le-
a better
tiene más opción.
All right.
choice in this case.
So I'll make it a good bond, and Mr. Ortiz will be able to make that through whatever bonding agency he
La casa de fianza.
hires, and it will remain a condition of bond that Mr. Ortiz is to have no contact, direct or indirect, with the victim, Ms. Fernandez Quintanilla. And he'll need to stay away from 2296 Herring Drive Southwest in Atlanta.
En Atlanta, no puede acercarse a esa dirección.
Ms. Hall, any other conditions?
¿Alguna otra condición? Le pregunto.
No, Your Honor.
No, sí,
Okay.
Ms.
Mr.
Hall, I'm sorry, Ms. Hall, are you gonna be the ADO on this case? The trial attorney?
Fiscal en este caso.
Most likely not, unless we move it very fast. Mr. Whitenhour will be back in July and he'll take over the case.
Thank you.
But between,
you can I was gonna say, you can contact me between now and then, though.
Okay.
right, if you cannot find that discovery in the next day or two, please contact Ms. Hall. I do not want to meet up with Mr. Ortiz again to hear that his lawyers don't have the discovery. If there are motions that need to be filed, they're probably already overdue. So let's get those in. I have no idea if there's anything to be suppressed or anything like that in this case. It sounds like it's not a stranger on stranger case, so I don't know what's out there, but I just want.
Scheduling order says all motions are due by June 3rd. If any motions require hearings by June 30th. Another status conference, August 5th, and then trial by October 6th. That's your scheduling order?
That's my order.
We will scour the office to make sure we do or do not have it, and then we'll make immediate contact.
Sounds good. Does Mr. Ortiz have any questions about the bond?
Tiene alguna preguntas?
We've got the interpreter right there.
Acerca de la fianza.
Pues lo tengo que pagar en mensualidades o como.
Do I pay it in payments, monthly payments,
The bond?
la fianza?
No, and most bonds will take 15% of the total bond as a one-time
No,
payment.
se paga una vez el 15% de la cantidad que le dan.
Some bondsmen will take a
Algunos van a
payment, but
tomar
that's
pagos, pero
usually not for these kind of
eso
cases.
no, usualmente no sucede en este tipo de casos.
And if you go to the same
Si usted va donde
bondsman,
el mismo, el
you
mismo
may
caso
get
que
credit
tiene,
for the
tal vez
9,500
le
you've
den
already posted.
crédito de los 9,500 que usted ya pagó.
Right. I would hope that anytime bonding, which was the original
Anytime.
bonds person, would say, we'll apply
Vamos a aplicar
the 9,500 to the 20,
500 que ya pagó a la fianza de los 20,000 que es la general.
especially since it's two of the same counts.
Porque son los mismos cargos que tenía antes.
All right. So Mr. Ortiz is going to go with the deputies. Once he posts bond, he'll be back out. I've got a copy of the indictment here,
Judge, may I approach?
please.
¿Y cuánto es lo que fue? ¿Cuánto es el monto de la fianza?
Pregúntele a su abogado. How much is the total bond?
20,000.
20,000.
So Ms. Hall, you may.
Encárgate con él. En la parte de atrás está el teléfono.
Uh-oh, I didn't check Ms. Hall's name. You sent me something saying check her name. Not this Ms. Hall, the Ms. Hall who got sentenced.
No.
Your Honor, that concludes my business. May I be excused?
I think so. We have one set of cases still rattling around. I don't know where Ms. Charles, her stuff is still here. So yes, you may. Thank you.
Okay, thank you.
Bye. Thank you for rushing over here. Appreciate it.
Just down the hall.
Were you still with Judge Brasher?
No, our offices, my office is on 8.
Oh,
The other side.
that's great.
Yeah, thank you. I'm gonna make it for this.
Oh, Holly Ann Strozier. Okay.
Yeah.
What kind of paperwork are they gonna need? Oh, okay. Yes, that should do it. All right, so Ms. Tucson and Ms. Jackson, we're just holding to see if we're doing something with Mr. Smith's cases. Are you here from Mr. Smith? Okay. So Barnswell was a plea. Bench warrant. No bench warrant for Conley. That's a reset for notice. Great to knock out 3 of Mr. Smith's cases. Have you met Reeves Hiles or Hiles Reed, the new? I heard good things, but he still is. He's our new gang prosecutor. So the guy, I'm now blanking on his name, he just left.
Michael was the name.
Yeah. Anyway, the guy we had, the bald guy with a little bit of beard, he left. And so we, Parrish, Mr. Parrish. Yeah, I know.
That's why you can't remember his name.
Yeah. And so Mr. Hiles is the new gang prosecutor for us.
Used to be in town, Desert World, he's the attorney for her for a while.
All right. It was okay.
Yeah.
Good.
Just playing with it before.
Yep.
Yeah, I was wondering if she was gonna. So does that mean you have to bring him back over and see who he's gonna hire, because she's private.
Yep. Yep. So let's just get him on the next available, whenever you can get him here. And it can be Zoom. It's fine to do a booth.
Okay.
Whatever's easier. And it doesn't need notice. So I don't even know if you could do like an add-on to it. We're not quite to every week we get a Zoom booth thing. We haven't done that in a long time because our schedule's been messed up. Are the lawyers out there negotiating? Is that what's going on? You just sat down. You can rest. I just was curious if they were. Okay. Yeah, Miss Charles and Mr. Richardson. Ms. Jackson, if this is keeping you from the farewell event and you wanted to go to that, you should go to that.
Thank you anyway, Yana, but I'm working remotely today.
Okay. All right. Okay. Well, if I go and they have cupcakes, I'll eat one for you.
Okay, enjoy.
Thanks.
What's he going to?
He's going to become the court administrator for a magistrate court, which is a burnout spot. Yep. Okay.
Oh, my mistake.
This is killing This is y'all time, I'm sorry. That's it. And even it is, I just got floor. I'm talking about something. 2 hours. Let's see, here, here. This is crazy.
They're gonna lie.
That's what I'm saying. Let me come up on what you can.
So.
Yeah, get early.
I got it. I'm good. You say.
Where is it? It's social. Social. Yeah, that's all right. I speak Spanish with. Stay there.
How you doing?
Why are you here bothering us?
I gotta go see my boy. Look, I greet you in the morning.
He does. I get the two, our favorite gun nuts are right after. Today we had the dog.
Judge, they trying to get me on the team now. I don't want to go part of it.
You want to push past it up, run me over.
Yeah, because he's sort of like, I'm sort of half in, half out of your way. And no.
So the camera guy see us doing this. It look good.
Yeah.
So they watch. The paper. You got no paper on you, officer?
Hey, let me take that one across the street.
What?
What are you talking about? No, payment thing, so they pay, I could, take out the money.
I don't know what you're talking about.
That's why here.
I didn't get a chance to do nothing.
That's why here.
They ain't know that now.
There's not.
Yeah.
She is a cute little button too. She, that I do FaceTime with her. She's always try to grab the phone down. Put her face in me. Give me a kiss. Kitty pie. I think she's gonna crawl probably by tomorrow. Really? I think so. Turning over, she can turn over one leg, she can't figure out how to turn that over. Oh, yeah, it's all over now. Yes, she gets up on her elbows, but she doesn't know what to do with her legs. I love her when she does it. I don't want to be held anymore. Where can I go?
Got somebody back here for love.
What? See, that's my regular love.
Another coffee.
That was the last one.
I'm looking for the list here because you sent it. So Hodges is off. Can't do Mitchell. Stokely doesn't have a lawyer. Farouk is off. Grant isn't ready. Holt isn't ready. So Sims we did add, and Hodge we added, and they're both supposed to plead before June 2. And
Hodge.
good. So if you don't mind reaching out to Mr. Matthews, well, let me ask, Ms. Charles is here. Hey, do you know, is Mr. Matthews has to resolve a case with you as well as another prosecutor? This is Sims.
Yes.
Is this going to happen before June 2? Well, if not, as long as you're ready to pick a jury, I am too.
Well, it might go non-negotiated.
Okay. Okay, we just need to lock in a date, that's all. All right, well, Ms. Nelson will bug you soon.
There was the other parts that A.D. Travis, Thomas, and so sure. I know Ms. Weiss had communicated an offer, and I just need to confirm whether he's adopting that must be applicable.
Okay, all right.
We have this case worked out substantially, and I'll try to represent 3 of the cases will be resolved, 1 by non-class, 2 by plea. 1, we have a time we want to present it effectively kind of non-negotiated court.
Okay.
High low.
Yep.
And I want to represent that to him.
Sure.
Then we would like to address the issue of bond that.
On the 4th case, and you will provisionally represent him, at least for purposes of bond on that case. Great, okay. We're good till, I got 4 o'clock, I got a meeting, so as long as we can do this before 4.
I'll talk fast and efficiently.
All right. All right. I don't know. The poor Judge Whitaker was stressed last night, texting some. We'll see. You know, the county's so big, you can move in one part of it and say, boy, look at all these signs. And you move in another part of it, look at all these signs. It's a very different dynamic this election than 4 years ago. There's not much activity on one side of the ballot. There's a lot on the other. That may make more votes in North Fulton than South Fulton, and that may make a difference. Who knows? I'm just less stressed than I could otherwise be, so I'm all right with that. That's great.
This location. It's right around the corner. So I'm really glad.
Yeah.
But, real organized. No.
Anything where first name asked me that's like anything.
You got my email that we can do July 11th instead of July 12th.
Yes, so your question is, if you just want to give the 12th away?
Yeah, as long as you don't tell me I don't want to switch, then I'll reach out to Amy Von Kelch to say, Ellerby is not using July 11th. I'm jumping from the 12th to the 11th. So there's now an open day on the 12th if someone were to ask.
I guess Ellerby said you because it was her case. She was just like, we're not sure yet.
Well, and they weren't when you first asked. And then I bugged them again, like, what is this? Not sure. And she was maybe going to do a divorce trial because she'll be in the family division by then. He said, I'm going to use that. So Judge Schwal wasn't going to use it for a criminal trial. That's why I figured it would be open. And he's like, oh, I don't need it. But Ellerby's like, I may use it. You know, she's going home. Okay, let's do a trial. But they don't need it.
2 weeks since you go do a trial. That's good. But yeah, I'm fine with that.
Okay.
But just to recap, what's that gonna do? Okay, so we'll strike a jury on the 11th instead of the 12th, which will give you that extra day.
Yeah.
Are you still, so you're gonna do still the trial on the 5th? Striking on the 29th of June.
Yeah, and it just needs to be a short trial. Yeah.
29th is striking, then have it the 30th, the 1st, 5th, 6th, and 7th, 8th meeting.
Oh, well, no, maybe it's not. I got it confused. Yeah, it doesn't need to be a short trial. It should be a long, but yes, we'll pick a jury on the 29th. If I had to bet, it would be Mr. Rooks. And then we'd go on the 30th, the 1st, the 5th through the 8th, basically. We had to be, yeah. And start making up for these trials that we haven't been able to do. And it will not be Beverly Taylor's case.
And he was the one that they really wanted to go out on, wasn't he?
Yep.
Okay.
Because they're not gonna try the two women and put you is an adventure.
Right. Well, I could say Carberry would be really good.
Yeah. April Woods still works with Judge Schwal, yes?
Yes.
Okay. Can you knock on the door? We need to get started. We'll run out of time. Thank you.
Guys.
Ms. Rivers, you ready?
Judge, okay, just for record. Can we reset this 1 week?
Sure.
Okay, I just want to make sure he and I are communicating. I want to go over the details. I think it's a decent recommendation, but I don't want to feel like he's being rushed. And he has some thoughts. I told him to get a piece of paper and write your thoughts down so you can communicate them effectively.
To be very clear, I'm not rushing anyone other than if we're doing it today, we need to start now because I have a 4 o'clock Zoom that I need to go get on. So
This is 1 week. I'll be right here.
well, we're going to talk about scheduling in just a second. Let me see what next week looks like because we then need to work through could we get Mr. Smith here in person, or would he be appearing virtually? And what's the comfort level with that? So let me look. So next week is not July.
Can I say next week, Judge? It could be a few days, just enough time for him to.
That's a June booth day. It's a booth day. Otherwise, you can do that.
Today's what, Tuesday?
Today is Tuesday, the 24th. So next week is a truncated week. I'm looking just at what we have this week. We can't do it tomorrow. No, we can't do it this week.
We do it Thursday?
That would be this week.
That's
Can't
fine.
do it.
Like I said, I just want to sit down and
Yep.
speak with him. That just felt rushed and.
I thought Monday, the 31st, Tuesday, the 31st, we had booth.
We have booth, we have transport.
Oh, we have a busy day.
We do.
Okay.
Busy day.
We can do digital.
I'm neutral on that.
If you're willing to do the booth, that's the 9th or the 7th of June.
What about the 31st? Is the 31st full?
Yes, I would say the 31st is full.
Because the booth is fine. By that time, all our issues will be ironed out.
Right.
I mean, I have to actually pull those cameras and how many are in.
I'm looking.
6 and 15, 6 and 8.
Funny, we have a different looking, we got this probation revocation count.
That's why it's in a different format.
Okay, that's in the afternoon. Status conference. Oh, that's the long one. Okay,
You got probation revocation,
yeah.
so that's what I'm saying. And
So why don't we do this? What about on the 1st? Yeah, if someone could lend us one on the 1st. We're already borrowing 2 slots from Whitaker.
Let me ask you if we have.
Okay. Mr. Richardson, I don't mean to leave you standing here. I don't want to put Ms. Nelson on the spot. Why don't we do this? We will look to see the quickest way we can get Mr. Smith back together with us again. My guess is it'll be in person. If we pencil in a date, then we need to check with you because, of course, you need to be available and you're pulled in lots of directions. And so we'll try to make it well before that date in early June that we know would work because sooner is better.
Ms. Nelson tells me I'll do a conflict and make this priority.
Okay, that's a nice power to have. So any of those scenarios, though, will give Mr. Smith a chance to think about it a little bit more so he reaches a comfort level of I do want to do it or I don't, because it sounds like there is a little gap in there and he needs to be comfortable taking the risk that I might agree with the state, I might not, and go forward with that. Okay. Do you have any questions, Mr. Smith?
No.
Other than when?
Because he's just concerned. His wife is here.
Sure. No, I asked who was here. She said,
Small babies.
Yep.
He's struggling.
Yep.
He's trying to get back to them as ASAP. as soon as
Yep.
possible.
We got a little cleaning building that we run together. It's just kind of like stressful for, you feel me? I'm kind of like in their lives, my kids' lives at the house, I'm very like helpful.
Yep. Okay. Well, Ms. Nelson's going to work on figuring out a date that we can get you here. It'll probably be in person. But worst case scenario will be on Zoom. You've done that before. We'll have the same conversation. It'll just be a different setting. Okay.
At that time, I'll have all 4 cases and I'll file entries and everything.
Done.
All right.
All right.
Thank you, Judge.
You bet.
All right. Thank you, Ms. Nelson. Maybe talk to you a little bit. Yeah, I love it. Thank you.
So Ms. Jackson, we are done. Thank you for joining. That plea to 3 cases, now may be a plea to 4 cases, but it will be on a different date.
Thank you, Judge.
All right, take care.
Okay.